May I have my lord's kind leave to mention the urgent matter of the determination of Honorable Justice Shogoto Mujumdar. For extension of interim order only, the division bench had confirmed till 27th of May. My lord. You ordered one? Yes. Today at 2 p.m. my lord? No, I have already given notice. I'll again give notice. Today at 2 p.m.
My lord, may I be
My lord,
may I be permitted to mention item number 21 of the day's list, my lord? It has come up wrongly under the heading new motion. It should be under the heading either new chamber matter or
new
chamber matter, your lordship.
So let it appear on Thursday.
My lord, the problem is Thursday. I'm in some difficulty on Thursday. So if your lordship could take it up today at 12 o'clock. I have already informed my other side. Mr. Shubhranshu Ganguly as well as his standing counsel, both of them have been instructed, my lord. I have already spoken to him. They have no difficulty if your lordship's list otherwise permits to keep it at 12.
One thing as a
Item number 21.
As a specially fixed matter, I can keep it tomorrow also as
Yes,
a chamber matter. Only this matter.
Yes, your lordship. That would be
only this matter in the chamber.
Yes, and before the entire list, if it is kept,
Yes,
it is kept tomorrow at the top.
Tomorrow at the top, only this matter will appear as chamber. Item 21.
Deeply obliged. I'll inform them.
May I please to mention a matter? This is in relation to urgent determination of Justice Mojumdar. This is a suit where parties have settled. We just want to mention it for withdrawal of this. If it can come up to be mentioned tomorrow.
It can do it before the regular bank.
The parties have executed a terms of settlement and where we have to comply certain obligations. Hence, we are also withdrawing certain proceedings before the division bench tomorrow. That is the reason if it could be mentioned. To be mentioned tomorrow. I'll just place the particular.
My lord, may be permitted to mention a matter. This matter was mentioned last by me on Friday, my lord.
Matter?
No, my lord.
Mention afterwards. When
My lord, your lordship had directed the matter to appear as to be mentioned today. However, my lord, the matter is not listed today, my lord. It was mentioned on the very last Friday, my lord. It is a suit
give
for
the slip.
my lord.
Lordship, this is to mention a matter which is at court number 40, Mr. Justice Majumdar's court. Because of an urgent determination I'm mentioning over here, it's a PLA matter. The proceedings of the suit is to be withdrawn by the petitioner because he is incurring a huge cost. So that's why he wants to withdraw the matter. It's a non-contentious matter though. But because the caveat is filed, we'll inform the other side as well. It's
Anyway, it's better you do it before the regular bench. This is not very urgent. Okay. Withdrawal of the suit is not very urgent. You can do it after application. Yes.
The problem is parties have settled in several other courts.
What is the urgency?
Several other courts, and one of the terms is that they will withdraw. That is why, otherwise we won't have trouble. Let it be there in the list tomorrow. I will get the letter. I will get the client. I will get the other side. All three.
Okay. It's appearing in the list. Anyway, give the slip.
My lord kindly gives a prayer for reconstruction, my lord. The department has given a report to the registrar that the fine.
Let it be put up.
Let it appear, my lord. My lord, I had mentioned twice, my lord.
Let it appear.
My lord,
Yes. Yes.
New chamber application item number 1.
My lord, this is my application. It's a simpliciter prayer seeking discharge of the receiver. Yes, on a ground of age and ill health.
In this matter, I am appearing for
my lord. Yes.
You are appearing for?
My lord, I am appearing for the receiver, Mr. Deepak Deb. My lord has, yes. My lord has also, I think, discharged in another matter before I am being. The same grounds, my lord. This is other, my lords,
No, I recollect.
Yes.
So he's suffering from ailments, I know that. So somebody else has to be appointed.
Yes, my lord, somebody.
My lord, in this matter, I appear for the petitioner. My lord. We have no contacts and we have no instruction in this matter. This is the difficulty, madam.
So you are for the
We have no
you are for
petitioner, madam.
That's all right.
You are
I
for
am
the
for the
receiver.
receiver because I am not seeking any prayer against him.
learned advocate representing the receiver and learned advocate for the petitioner executor is present. This application is sought for. This application is taking discharge of the receiver on the ground of his ailments.
Yes, age and ailment.
Age and ailments. You have annexed the documents also.
Yes, my lord. All the medical certificates are there
Learned
from
advocate for the petitioner peruse the medical documents filed in the application.
page 27 onwards, Annexure D.
Upon perusing the application and upon hearing the learned advocates, this court is of the view that this Mr. Dev, learned receiver, who is appointed in this case should be discharged. Thus, I discharge Mr. Dev in this matter as a receiver. Let dash. I'll appoint him. Be appointed as a receiver in this matter. At the initial remuneration of dash, learned doing receiver is requested to hand over the relevant documents to the newly appointed receiver, and learned advocates appearing for the petitioner shall also extend necessary cooperation with the newly appointed receiver. So,
My lord,
liberty
one request is, my lord.
any other remuneration to be
Yes,
paid?
my lord, 87, he had received a remuneration of 100 GMs and that has been continued since. Let there be a discharge, consolidated remuneration at the moment of discharge.
How
Kindly.
much do you suggest?
My lord, he's holding 43 lakhs.
43 lakhs he is holding till.
Yes, he will transfer this.
So from that he
can deduct something.
okay. The outgoing receiver be paid a remuneration of 6,000 GMs to be 6,000 GMs.
The previous matter is given 18,000 gold.
I think the
No, 18,000. Just a minute. Oh, okay. We paid 18,000 GMs to be adjusted from the amount which he is holding.
Kindly record that we have no instruction in this matter.
Although the learned advocate for the petitioner submits that he did not receive any instruction in this matter, but considering the documents furnished, this court is of the view that the necessary orders may be passed. Not again. Let there be let there be an order in terms of prayer A, B, C, and D of the notice of motion. The master summons.
My lord, there is a small typographical error in master summons. Over here, the order is as dated 24th August 1987, but actually it should be 26th July. It should be 27 July 1987. It's a
So
mistake.
then again, you have to withdraw this application file afresh.
No, my lord, this is a
Then it
typographical error that can be recorded perhaps.
okay. That should be August, July.
No, the actual order is dated 27 July 1987, which is at page 8.
No, I am granting you prayer in terms of prayer A, B, and C. Okay, so,
Yes,
so whatever is there, that has to be followed. Otherwise, you have to.
of course, this is an affidavit in the support of master summons. So this is the prayer. So my lord,
Anyway,
The-
after all, Mr. Dev is discharged.
discharge. Then that
There is no dispute with
Yes.
regard to that.
and my lord, affidavit of service.
Let the affidavit of service file be kept with the record.
Item number 2, Shiv Prakash Kajaria.
Lordship, this is my application for substitution, my lord. My lord, the suit for partition, my lord. The defendant number 9A died on 29th of August 2024. And my lord, the communication from the end of the defendant was received by the plaintiff on 23rd of January, my lord. The lordship will kindly take page 13. The pleading is here, my lord, and lordship will kindly take page 26 once. Lordship.
Six.
Yes, fine.
No, 26, 27.
Lordship, this page, my lord, 26. the prior-
Yes, 26.
This
You
is
have
the
received intimation?
This is the intimation which I have received from the legal heirs of the deceased defendant. On, my lord, kindly see the date, my lord, 21st of January 2021. I have received it on 23rd of January.
23rd of January is received by you. This letter is dated 21/1.
Yes,
And you have received on 23rd of January.
yes,
And he died on 29/8/2024.
yes. My lord, hence, my lord, I am praying for leave to for deletion of the name of the deceased defendant, and my lord, seeking my lord, for inclusion of the legal heirs of all the deceased defendant. I'll be praying orders in terms of
So 9A. 9A is who died?
my lord,
9A.
9A.
9A died.
Yes.
And legal heirs are already in the record.
No, we have to, by this application we are uh, substituting the legal heirs.
Annexure E.
Yes, ma'am. Lordship will kindly see the plain, the amended plain at page 32.
Okay.
My lord,
9A died. 9A1, 9A2, and 9A3.
Yes, ma'am.
Yes, record an order. Learned advocate for the petitioner is present. Our learned advocates for the petitioner. This is an application for substitution of the years of defendant number 9A, Indira Kejriwal, who died on 24. Yes, which page? 32.
Yes, ma'am. 32.
No. The intimation.
Intimation is at page just now. Page 26.
26. Yes, who died on 29/8/2024. Sufficient cause is shown for not preparing the application for substitution within the period prescribed by limitation, as the intimation is received on 21/1/2025, 21/3/2025 by letter dated 21/1/2025, addressed by the heirs of the deceased defendant. Thus, this delay should be condoned and the prayer for substitution should be allowed.
My lord, I'll be seeking orders in terms
Yes,
of prayer.
let there be an order in terms of
Prayer
prayer
to E.
A, B, C, and C, D, and E of the master summons dated 25th day of April 2025. Liberty to mention. after
Lord.
taking necessary steps.
Grateful.
Item number 3, 6, Mansoor Ali.
I'm appearing, my lord, on behalf of the judgment debtor. Now, this was a suit.
You're for
Decree holder, my lord.
degree holder, yes.
That in this execution proceedings, there is already an order of stay passed by the executing court on the ground that, my lord, the decree is nullity because it was not a commercial dispute. Because it should have been a commercial dispute.
There is a stay, the stay is continuing.
Yes, my lord.
No, my lord,
The lordship will kindly
My
see
lord,
a few
take it.
orders for that.
No, question
Justice
is,
Sinha had passed, my lord, the
question is, this bench can hear this matter, this execution.
Yes, my lord.
case. So, with regard to the decree being in a nullity, this matter has to be heard out.
My lord,
my GA1 is
So
to that.
GA,
respect.
GA1,
Yes.
my lord,
GA1 affidavits are complete.
my lord, that has been disposed of, my lord.
GA1,
And yes, G1
order of
in
disposal.
order 9 rule 13.
Is
Where is the
GA1
order of
in
disposal?
EC. My lord, may I clarify? My lord, this was a suit filed by the plaintiff. The defendant, my lord, did not represent and ex parte decree was passed.
Yes,
After that, my lord, they came up before the executing court to execute the decree.
right.
At that point in time, we took up the point that this should not have been an ordinary suit. It should have been filed before the commercial division. This court, my lord, that is the executing court, was pleased to pass an order of stay on our application being GA1. Simultaneously, we had filed an Order 9 Rule 13 before the suit court. The suit court, my lord, has disposed of our Order 9 Rule 13 by dismissing our Order 9 Rule 13 application, saying that the grounds under Order 9 Rule 13 were not justified. However, the suit appears to be one which ought to have been filed before the commercial division. Now, the situation is that my GA1 application is before your lordship.
So that application has to be heard on
Fine.
affidavits.
Yes.
So
Affidavit exchange,
affidavits be filed.
My lord,
but affidavit has not been exchanged.
No, let affidavits be
my
exchanged.
lord,
Yes.
let it. My lord, that GA1 was filed by my learned friend
Still 15th
on the
April,
ground.
Sir, Actor James Pulaki. 15th April 2024 order, your lordship will find there is a stay. Sir, Ibarra.
That's correct. That's right.
Whatever
That's
it is,
true.
GA1 has to be heard out.
That's true, my lord. But that was for a limited purpose. That means my learned friend's client filed an application under Order 9 Rule 13. Till to the disposal of that petition, the stay was granted.
Yes. Now, in this
Now,
execution case,
now, my lord, that Order 9 Rule 13 has already been disposed of and it is dismissed.
now question is GA1. This is with regard to execution case. Okay. Now this GA1 of 2024 is to be decided on affidavits. So file your affidavits. The matter will be taken up after vacation. Yes.
Kindly, my lord, continues the order. That is 15th
No, my lord,
April
that
2024.
cannot be.
Then I will have to invite your lordship into the
Yes.
fast.
Let
My lord, a substantial
learned
amount may be
advocate for the
deposited by my
petitioner,
learned
degree
friend's
holder
client.
and learned advocate for the judgment debtors are present. GA1 of 2024 is taken up for consideration. Heard learned advocates. As this matter is required to be heard on affidavits, let affidavit in opposition be filed within 1 week after vacation, reply within 1 week thereafter. Let this matter appear on 24/6/2025.
Lord, let the stay be continued. Lord,
My lord-
kindly have a look at the order of 15th April.
My lord,
He was passed in which case? Execution case?
GA1 of the execution case.
No. This is order.
15th April 2024.
You see, it would not be proper to proceed with the including IA, GA1, unless the petition is disposed of. So,
The lordship has already
So
given a
GA1
short date.
so execution proceedings was not continued because Order 9 Rule 13
Yes,
is
my lord.
pending. Okay.
Yes,
That's my
Now,
point.
now Order 9 Rule 13 is disposed of. This is the
my lord.
now as Order 9 Rule 13 is disposed of, these execution proceedings can continue. If execution proceedings can continue, This GA1 of 2024 is a part of the execution proceedings.
I bow
My
down,
lord,
my lord.
Anyway, if,
my lord, in that situation, my lord, GA1 has no leg to stand upon. My lord,
We have not even
it is not
started our
existing as
GA.
existing.
started our hearing. with
anyway, you
GA1.
come after vacation.
My lord,
So, Lordship, that's
in
fine.
that event, my lord, let my clients, let my landlord client to direct to deposit a
This is
substantial
not a
amount.
court of
My lord,
Let him, you file your affidavits, I shall consider that.
You will kindly allow me to file. Your Lordship has granted me time to file affidavit.
Your
in
learned
reply.
friend will file affidavit to your
Opposition,
application.
I'll file
You
my
file
reply.
reply. Let this
But
matter come
kindly
up.
let it come up on 26th instead of 24th.
Okay. 24th jagah 26th kore deben.
For hearing of GA1. I'm deeply
Yes.
obliged.
Item number 4, Padma Sonthalia.
Lordship, I'm appearing on behalf of the degree holder. I'm led by Mr. Varun Kothari. Kindly give a short pass over. He is in 41.
Not today. Come on Thursday.
Item number 5, Devashish Vishwas and others.
My lord, my execution application, my lord.
Yes.
My lord, a suit was instituted by the plaintiff, my lord, wherein they had sought for certain decrees, but all those prayers, my lord, were rejected, and subsequently, my lord.
So this is application, your application.
Yes, my execution application, my lord. We had sought for a few counterclaims, my lord, which stood allowed. Now the plaintiffs were required to vacate the property within 60 days, my lord, of
Your
passing
Lordship,
of the
appearing for
decree.
the respondent, Your Lordship, I'm praying for shifting of this matter after vacation, Your Lordship. There's the main suit, Your Lordship. The main suit is also listed before Your Lordship. Your Lordship have kept it after vacation, Your Lordship.
But the decree for eviction has been passed, my lord, and thereafter appeal was preferred and the appeal was dismissed. My learned friend's client has not taken any steps whatsoever insofar as the appeal is concerned.
On April 21.
Yes. It's almost been a month, my lord, that they have not taken any steps and I'm entitled to execute my decree.
No, it is appeal is disposed. Oh, it's a dismiss for default. Dismiss for default.
Not dismissed, it's on merits, my lord, that it has been.
No. APD 3 of 2025.
My lord also appreciates that
Dismiss
they
for
have,
default.
my lord also
Yes, Your Lordship.
appreciates that they have not
We
taken
could
any
not,
steps.
we could not appear before the division bench. Your
My lord, I'm being led by Mr. Ghosh, my lord.
My lord, the appeal has been dismissed. The appeal was made anyway, my lord. Stay was conditional. They never complied with the stay.
Anyway, did you file any application for
Nothing.
restoration?
I haven't, Your Lordship. I have not been instructed yet, Your Lordship. Kindly
No
keep it after
instructions
vacation,
only.
Your Lordship.
No instructions only. My lord, they did not even allow, my lord, did not even deposit
Let it be taken up after vacation.
My lord, kindly, my lord, allow me to.
You see, few days you will not suffer anything. Let them take instructions.
Don't even have instructions whether they will file or not. My lord, today I'm
Your Lordship,
entitled.
the main
my lord,
suit is also
I'm
listed
making it
before
very
Your
clear
Lordship.
on Tuesday, on the reopening date, it will be taken up.
Well, let it be
I'm so
taken up on
grateful, Your
Thursday.
Lordship.
Let them at least say whether they have
Honorary
instructions
advocate
to
for the
my lord,
petitioner,
withdraw or not, to
Agree.
file a recalling or not.
learned advocate for the petitioner degree holder, and learned advocate for the judgment debtor as present. Time is sought for on behalf of the judgment debtor to take necessary instructions. It is submitted by Mr. Ghosh, learned counsel for the degree holder, that although the appeal preferred by the petitioner, judgment debtors are dismissed on April 21, 2025, but the judgment debtors have not taken any steps to file any restoration application.
There was and kindly record there was anyway no stay on the appeal because they did not comply with the conditions of the appeal court.
Execution will proceed if there is no stay.
There was no stay anyway, and the appeal is also gone now.
However, in the facts and circumstances, an opportunity is granted to the judgment debtor to take either necessary instructions or necessary steps in this regard. The matter will appear on 10/6/2025, and no further adjournments will be granted.
I'm obliged, Your Lordship.
Yes, it is peremptory on 10/6.
Obliged, Your Lordship.
Item number 6, Thompson and Company Limited.
My for execution.
but I was be praying for issuance of a warrant of arrest. On the last two occasions, direction for affidavit of assets were passed. They have not filed. There is an appeal pending. They have chosen not to secure the money. So the stay application has been disposed of. The appeal court has not granted any order of stay.
When did the matter appear before the appeal court?
Last week.
Where is that order?
There is no stay. The previous order.
Let me see the order.
Yes,
So,
kindly.
way, this order was.
Kindly seize this order, Milord. Kindly seize this order.
Before Mr. Gupta proceeds any further, I was just seeking for a short passover.
No, this was the last order. Question is thereafter, after 13th May. After 13th May.
But before this honorable court or before the appeal
Before
court?
the appeal court.
No order was passed. No order for stay was passed because the stay application is disposed of. Your lordship knows under order 41 rule 5.
No, what against the appeal against the decree or execution order?
It's a decree. Appeal against a money decree.
No, this APOT.
APOT is the appeal against a money
I was
decree.
a member in the division bench. That is what.
Yes, now a different division bench is hearing when an honorable.
Whatever it is, I passed an order in the division bench. So I am asking whether it is from this execution.
No, it is not from the execution. It is. May I indicate one thing? There was a suit. If your lordship kindly permits me, there was a suit for eviction and mean profits. In that suit, in a chapter 13 application, decree for eviction was passed.
A mediator was appointed.
Yes, mediation failed, report filed before the division bench. Nothing is there. But if your lordship kindly gives me 1 minute, I shall appraise your lordship in a nutshell the facts. Suit is for eviction and mean profits. In connection with the suit, the plaintiff takes out a chapter 13 application for summary decree. Allowed, the decree for eviction is passed. Appeal preferred, appeal dismissed. Now, the mean profit aspect has been relegated to a special referee. The special referee, after considering the evidence of the plaintiff and in which the defendant chose not to lead any evidence, files a report. That report, gives rent at the rate of occupational charges rather at the rate of around 60 rupees per square foot.
The judgment daters
have vacated the suit property. Now it's execution of only the money decree, only the money decree component. Now, from that report of the special referee, both the plaintiff and the defendant have challenged. The plaintiff said it ought to have been more. The defendant said it ought to have been less. So the defendant's application was dismissed. The plaintiff's application was allowed by enhancing the quantum assessed by the learned special referee and passing a decree to that effect. Now there are two appeals pending. One is an appeal from a decree, which is passed in favor of the plaintiff, and one is an appeal from an order, which is from the dismissal of the application of the defendant for reduction in the assessed mean profit. In both these appeals were taken up by the honorable division bench when they said that they will not secure the amount, so the stay application was disposed of. There is no stay. Paper books are complete. Hearing has not been done. It is there. On the last order, the hearing has begun. It's not concluded. But this honorable court, on the last two occasions in the execution, have passed orders directing them to disclose their affidavit of assets.
What is that order?
Yes, your lordship will kindly see 17th of April order,
Lordship, may I only I was seeking for a short passover, subject to what, because I have two leaders in the matter. If your lordship allows me, just a short. Very well. Very well.
If your lordship kindly sees the 17th April order passed by your lordship.
17th April.
Yes. Last paragraph. Pendency of the mediation will not prevent the judgment debtors to file their affidavit of assets within the next date of hearing.
So where is the direction to file the last order? Where is the direction?
But this is the direction.
No, this is pendency. For the earlier direction.
This was the first order.
Oh, this is
the first order. Thereafter, kindly takes a look at. The next order is 29th of April 2025. Your lordship simpliciter adjourned the matter. Now, 13th May 2025 is your lordship's last order, where your lordship would kindly have a look at paragraph 2. An appeal is already preferred against an order and the matter is pending before the appellate court, but there is no stay of further proceeding of the execution case. Then paragraph 4 kindly sees parties in the meantime may take necessary steps to obtain orders from the appellate court. My lord, your lordship would kindly recollect, my lord, my learned advocate on record, Mr. Basu, had mentioned this matter for inclusion, that the honorable division bench, my lord, while taking up the appeal, said we are not recording any order with regard to stay. So, my lord, as on date,
On which date?
I'm sorry, my lord.
Which date that order was
No,
passed?
they are saying the division bench said I am not recording any order. There is no stay. I am not recording any order because of the coordinate bench order already being there, which your lordship has just now seen. So, my lord, I was humbly beseeching that since your lordship has already been pleased to pass a direction for, my lord, filing the affidavit of assets, and your lordship specifically said by the 13th May order that, my lord, this matter would appear on the 20th May, and in the event they cannot obtain any stay, but this should proceed, and it's a money decree. Order 41, Rule 5, filing of an appeal does not amount to stay. So let them, my lord, file their affidavit of assets. What is preventing them? But since they have not filed,
Lordship, may kindly hear me.
The holder petitioner is present.
There are dues in excess of 3 crores.
That although there is no stay of the decree passed by the trial court, passed by this court, but the judgment daters have not filed their affidavit of assets. Mediation proceedings have failed.
There's a failure report filed.
Proceedings have already failed.
Lordship, may kindly hear me.
As time is sought for, an opportunity is granted to take necessary instructions to either file the affidavit of assets by.
Lordship, may kindly hear me once.
Yes.
Lordship, the appeal court is already hearing the matter. If your lordship,
Very well,
your
hearing
lordship,
the matter, let
lordship,
it be heard.
kindly.
Where is the
allow me.
order of stay?
There's no order of
Very
stay. Your
well.
lordship, I cannot shy away from that. But your lordship,
To obtain an order of
your
stay,
lordship kindly considers one more judgment. Your lordship passed by your lordship.
Yes.
Kindly, your lordship kindly takes up this order, wherein your lordship, under a similar circumstance, your lordship was pleased to grant some time to the since there was an appeal pending.
That was
But
already
I have
granted.
already granted.
Already
two times.
granted.
Your lordship will kindly see, and here your lordship, the appeal is being heard. Lordship, I'll produce the order of the
When was
learned.
the decree passed? You see.
So that is not reflected in the order,
But you see, this is a long time order, 27th February.
Yes.
Long time it is pending. That
Yes. It's a
Lordship,
money
the
decree,
appeal
no
is
stay.
heard.
Everything
Lordship,
is
the appeal is being heard. Your lordship kindly sees the appeal court. Your lordship, we have in fact begin. Lordship, we have in fact begin the argument. If your lordship sees the appeal court's order, so I'm only humbly
The appeal was
some
called
time
on
may be
2
given so that we
occasions.
can get the appeal heard.
The appeal be heard, you get the appeal heard. In the meantime, you prefer an appeal against this order, get it stayed. Either.
My lord, will kindly not give them an
Keeping
option.
it on Thursday, okay.
Yes, my lord, your lordship will
I'm
kindly
not
not.
passing any order, I'm keeping it on
But
Thursday.
your lordship will kindly not give them an option. May I humbly submit one thing subject to my lord's kind
I'm
consideration.
not passing any order. Acha, okay,
My lord,
Shall I present and submit so that although there is a stay of the
no stay.
no stay.
decree passed by this court, but the judgment debtor have not filed the affidavit of asset, the mediation proceedings have already failed. As time is sought for, opportunity is granted to make necessary steps.
To take necessary steps and come ready on 22/5/2025. Because you are praying for time today, I'm granting you time. No further time will be granted on 22/5/2025.
Kindly make this a peremptory opportunity.
Yes,
The appeal
time
court.
will be granted.
Yes, the appeal court specifically said we are
Let
not
them
recording it.
justify their stand.
Very
Okay?
good.
So kindly appreciate that the appeal court is in scene of the matter, and we have already commenced our arguments.
If I allow your prayer that the appeal is pending, appeal court is in cessation, then all the matters I have to grant. If I consider your case.
May I file the affidavit of service?
Anyway, come ready on Thursday.
Not if your lordship kindly request me the affidavit of services.
The affidavit of service file be kept with the record. Great.
Timber application adjourned at number 7.
My application.
There are 2 general applications appearing in the list.
One of your application was mentioned and it is fixed tomorrow.
I know, I'm sorry, yes.
The sole application.
I know, that,
sole chamber application.
yes, yes. Mrs. Ghosh has informed me. Mrs. Ghosh.
Sole application.
Yes, yes. Yes, Mrs. Ghosh has informed me. ठीक है चलिए, sure. Number GA2 and GA3
Yes.
are two of my applications. Now, so far GA2 is concerned, this is for revocation of the grant. Now, during the pendency of this application, it was observed from the court, I said that the consent by which my client has given a consent is forged, manufactured signature. So based on that, GA3 was filed by me for appointment of a handwriting expert under the Central Forensic Laboratory so that handwriting can be compared. On GA3, an order was passed on 26th of November. 26th of November in GA3, the order was passed appointing Central Forensic Laboratory to compare the signatures and to give a report.
Report was also
Yes.
submitted.
So based on that, we have done all the formalities. The main important part which we have done is the order records, we had to deposit with the registrar several original documents. Or she will kindly come to internal page 6 of the order. Internal page, after all record in the ordering portion. Internal page 6 of the order of 26th of November. 26th of November.
Page
6. Internal page 6 of the order. 26th November order. 26 copy नहीं 26 November. This is the order by which GA3, now you will see after recording all this in the ordering portion. Yes, the ordering portion, page 6. In the light of the aforesaid discussion, it is ordered as follows.
Yes.
So after this, the registrar was directed to send the following to the laboratory, the director of Central Forensic Laboratory.
Yes.
The Roman 2 of page 6 records, the learned advocate on record of the petitioner is directed to submit the original of the following documents. So the list of documents are given, including my PAN card and other documents, before the registrar within 7 days of this order. Then the bank manager, this did not happen. So the direction on the
originals are lying.
Yes. So the originals are lying, and we have the next page. The registrar was to communicate to the forensic laboratory, which the registrar has done. So today, we have done. This is the letter by which we have submitted 3 original documents as recorded in this order with the registrar original side. Based on this order, a report has come from the forensic laboratory. Now, so GA2 is now has lived its life. GA3, because there is no further order I can ask in GA3, Malad. The GA3 can be disposed of because there's only prayer in GA3 was
for appointment of the
yes, forensic expert and
they
file
have
a
submitted their report.
They have submitted the report. Based on this report, my GA2 will
do that to GA2.
My lord, that can be after vacation. It can be pushed because my lord, we can push after vacation. The only thing I want today, my lord, the original be returned to me with the registrar.
My lord, I am appearing for the heirs of the executor. My lord, I
the matter after vacation.
After vacation.
Learned advocate for the applicant in GA2 of 2021 and learned advocate for the heirs of the executors are present. The prayer of learned advocates, let this matter.
It's GA2.
GA2
data.
be fixed on 12. Okay, let it be
After 15th.
17.
Yes.
6, 2025.
There's no data.
Under the same heading, top. Item 8. Learned advocates for the applicant and learned advocate for the heirs of the executors are present. Application GA3 of 2024. The applicant. What is your name?
My client's name.
Yes.
Meena Dash.
Meena Dash.
Meena Dash.
Sought for appointment of foreign FSL.
You forget the client's name at times.
FSL to obtain the report with regard to relevant documents relied on in this case. However, as the forensic experts were appointed and report already submitted, nothing remains in this to be decided in application GA3 of 2024. Thus, GA3 of 2024 stands disposed. As it is submitted by learned advocate for the applicant that the original of the PAN card, Aadhaar card, and identity. What are the documents?
These are
Original of PAN card of the applicant and only PAN card. So what is the
no, there are some other documents, my lord, which is also recorded in the order.
and originals of Annexure G are
But that portion can be copied out this letter.
only these two annexures, not server copy. This is not necessary.
Approved.
Annexure
No,
G
yes,
and Annexure H.
The two documents.
Originals of Annexure G and Annexure H.
Annexure H2 GA3. These annexures were in GA3. GA3. ठीक.
One indulgence, my lord. My lord, I have applied for the certified copy of the forensic report, but till now haven't got it. My lord, I be supplied with a copy.
I've obtained certified copy.
With a Xerox copy, my lord.
May I take back the original letter which I've given to the registrar? The chobi tule na unai take a picture of that. Obligement. May disposed of. Obligement.
Item number 9, for Roy Choudhury and
So
Associates.
this is my application for
nine
setting
idea
aside
for
of
D1 and
abetment
D2.
and my lord for substitution of my lord the deceased heirs of the deceased defendant numbers 3 and 7. I am for the plaintiff.
I am for defendant number 1 and 2. Before my learned friend places his application, there was a direction upon me to file my affidavit. My affidavit is ready. But my lord, what has happened? The advocate on record's father has had a brain tumor. He is there in the hospital. I couldn't carry the original, otherwise I would have filed it today. No, it's ready.
It was to be
The
filed by
original
13.
The original is with.
But
I shall give my learned friend a copy. Okay, sir.
no, only
Day after on Friday, my lord, it won't be possible. Your lordship will serve him in the meantime. Yes, it's ready.
And only one thing,
But
my lord.
subject
I'll
to
just
he
be-
comes.
No, that is all right. I'm on one thing, my lord.
What is
The
it?
defendant numbers 1 and 2, my lord, have got no role to play with the
My lord,
substitute.
that is, we have already filed our opposition. Mr. Ghosh always contest. 21st, my lord, 23rd, it will be a bit difficult. We shall serve them in the meantime. 9th, yes. We shall serve them in the meantime.
They cannot object to the substitution.
Just, my lord, may kindly records, my lord, that this adjournment which I am seeking, my lord, is on account of health of the advocate on record's father. My lord, it will be otherwise, my lord, the same will be used against us. Extremely grateful, my lord.
But the directions are peremptory, my lord.
Yes,
because
yes.
They had to file it 1 week back.
My affidavit is ready. Yes.
Great.
Extremely grateful, my lord. 9 and 10.
Both matters, my lord.
9 and 10.
Similar directions being passed.
Extremely grateful, my lord.
Item number 11.
Lord, I appear for the
My lord, I am
Three
for
holder, my
the,
lord.
I am for the judgment letter, my lord. On the previous occasion, my lord had passed an order directing the judgment letter to file their affidavit of assets and wakalatnama. My lord, I had sought an extension on the second occasion. So, my lord, there has been compliance of my lord's order. Now,
I
my
don't
lord,
think so, my lord.
I have-
Let him file that affidavit of assets, my lord. I'll show whether it is in form or not.
and my lord, it is already filed, my lord. Yes, my lord. My lord, may I indicate two things, my lord?
No,
There
let
is an
him, let
issue.
him file it.
There is
Your
an
lordship
issue of
kindly see,
my lord will
lordship will kindly see the affidavit of assets, my lord,
Yes, yes.
whether it is in form as prescribed in the CPC, my lord. He has just handed over me today in the morning right now.
I had
a
emailed
copy.
it to his advocate on record. The counsel, he was not with a copy. I have handed it over a copy to him as well. I'm trying to comply with my lord's order in every letter and spirit, my lord.
He has not given any
My lord,
particulars of the landed
before
assets.
before he places my affidavit of assets,
Let me complete.
my lord,
Let
we
me
should
complete.
also look at the application, whether the application is maintainable or
You
not.
have not taken out any application.
My
Such
lord,
application. No, my lord, I want to cross-examine the. I want to examine the.
Before that.
No, my lord, your lordship will kindly see the CPC, my lord. Kindly sees the CPC, my lord, once.
My lord, once he is completed with his submissions, my lord, I shall also indicate why in law this particular application is not maintainable.
You have not taken out your application. Your application is not on record. Whatever is there, let us first deal with that. Kindly comes to my lord, order rule 41. This is regarding examination of judgment debtor, my lord, and your lordship will kindly see affidavit of assets. It has to be filed in Form 16E, whether he has done so or not, my lord. Kindly sees Form 16E. Sorry, 16A. Kindly comes to my lord, the appendix E, 16A. But may I just hang, I have a copy open, my lord.
The technical defect is preparing.
He has not given what money is there in the bank accounts. He has not given what stocks and shares does he have. The property details are not there. Other securities he has not given, my lord. All he has done is now, my lord, kindly comes to page.
Did he say that apart from this, I don't have any other assets?
No, my lord. He has not said so.
So, question is.
What he has done is, my lord, kindly comes to page 3, paragraph 4.
Page 3, paragraph 4.
The judgment debtor has sufficient assets to satisfy the decree. Insofar as the decree for such and such is concerned, I say that the amount held asset situated at Moja such and such is sufficient asset to secure any claim of the purported decree holder. Now, my lord, he has annexed the sale deed of this particular land, my lord. Kindly comes to, my lord, page 7, if I am not mistaken. Yes, my lord, kindly comes to page 7. Next page, my lord.
Page 7.
7.
Yes.
He has annexed some deed. Sale deed kindly comes to the vendor and the purchaser. Vedic Diamond IT Links Private Limited. Kindly sees who's the judgment debtor, my lord. Green Tech IT City Private Limited. He has not said that Vedic was the earlier name. He's trying to mislead my lord's court. I have checked the schedule of this deed. It matches with the land particulars given.
Whatever he will have documents.
So, my lord, he has not
to clarify.
No, my lord, he has not complied with your lordship's order. He needs to be arrested, my lord. That is all I'm saying. He needs to be arrested.
One minute. my lord will only take up his execution application. My lord, his execution application is in respect of an order passed by the Housing Industry Development.
No, I am not going to. If there was a direction, you comply that. I shall hear your application on merit.
I have complied. My lord,
Yes,
may
yes.
I
There is some defect you
my lord,
play.
may I indicate one thing?
Yes.
My lord, this court does not have jurisdiction
Very
because
well.
it has to be tried. This application has to be filed under the Bengal Public Demand Request.
I shall
My lord, may
consider
only
that.
show that.
You come out with. Have you filed an application for dismissal of this execution
This is
case?
the point of law. My
No,
lord.
no. You come with an application.
My lord,
Learned
if I
advocate.
grant me that liberty, I shall file an
Learned
application.
advocate for the judgment decree holder and learned advocate for the judgment debtor are present. Although affidavit of assets is filed, but it is pointed out by the learned advocate for the decree holder that the said affidavit is incomplete as because the documents regarding sale deed which the judgment debtor has filed, it is not clarified in the statements made in the affidavit as to the nature of ownership of the judgment debtor with regard to the said property, nor it is stated how the judgment debtor is the owner of the property which he seeks to rely in his affidavit of assets. Learned advocate further submits that it is not in the form 16A, thus it should not be relied upon. In the facts and circumstances, this court grants an opportunity to the judgment debtor to rectify the mistake and file a fresh affidavit of assets by
Thursday.
10/6, making
Thursday, my lord. Your lordship will kindly see it's pending since November. He has been directed to file.
Submission that he does not have jurisdiction. My
it by
lord,
10/6/2025. Although learned advocate for the judgment debtor submits that this application is not maintainable with regard to the jurisdiction, but no application till today has been filed in this regard. Thus, in the event the judgment debtor intends to contest the said application, he may come with an affidavit or with necessary application. But however, the affidavit of assets shall be filed on 10th June 2025.
My lord, your lordship will provide for.
does not will file my application.
You see, so long period it is pending. You are going on.
I had taken out the application. It was not in proper form. It had to be in an affidavit and a master summons. But tomorrow morning itself, I will seek my lord's leave for short service. My lord, be that as it may, my lord will only see that it is not maintainable in law because under section 40, it has to. He has to go before the Bengal.
You come on 10th. I shall consider.
My
But
lord,
you file your affidavit of assets to comply this order, and you come on 10th.
My lord, I have
My lord,
already given
in that case, my lord,
what will satisfy the particular decree.
my lord, kindly in that scenario, my lord, since your lordship is giving them time, my lord, two things, your lordship, I'm seeking from your lordships. First is, your lordship will kindly provide consequences of not filing by 10th. Second, my lord, is he has come out with certain bank statements, bank accounts. Kindly sees page 6.
No, I have granted him opportunity to rectify all those things. Come in the proper form with necessary particulars.
No,
Okay.
only thing, my lord, I am seeking is let there be an injunction restraining him from operating these accounts.
It's an application which is not maintainable before this court.
Okay.
It is an application not maintainable.
In the
before this court.
meantime, the judgment debtor shall not operate the bank accounts.
My lord, it will cause problem, my lord. I have to give salary. These are salary accounts as well. My lord, he has no case.
Then you pay my money. You pay my money, and then you pay the salaries.
Particular appropriate authority. My lord will only take up the.
Anyway, let there be a stay of operation of the
My lord, I'll have to.
of the bank accounts without keeping the decretal amount aside.
The land is not.
You keep the decretal amount aside and you make the payments.
Use the land. My lord will use the land.
Land is not even theirs.
I'm not.
It is in the name of some other company.
You keep this amount aside. Do whatever you want.
He does not have jurisdiction.
Several times you are saying all these things. You have not taken out an application.
This is how, my lord, he wants to.
How long this application is pending?
My lord, I had filed it last year, my lord. September.
Occasion, my lord.
You have appeared last 3-4 occasions, sir.
Now come ready. If the points of law is there, definitely it will be considered. You keep that amount aside. Okay, and thereafter you operate that amount.
And in that case, since your lordship has said so, then let him also file the bank statement showing that this money has been kept separately.
That is not necessary.
Item number 12, Shamanto Sen. Samohita Sen. Sorry. Samohita Sen.
You are appearing for?
I am appearing for the judgment debtor number 1.
Yes.
I'm appearing for the decree holder.
The talks of settlement were going on. Dealing with this matter and Mr. Shakti Singh is appearing with the decree holder, my lord. The talks are still on, my lord. I will humbly beseech the final matter 1 week after the event. My lord, another thing, the judgment debtor number 2 is not appearing. Judgment debtor number 3 is for judgment debtor number 3. The right onward terms of the parties, all the 3 parties had signed on a terms of settlement based on which decree was passed. Right, the decree holder's contention that we have not complied with the decree. And my lord, the judgment
Proper forms are not issued so that it can be carried out.
Yes.
Proper forms.
Right.
Execution of proper forms are necessary.
Absolutely. My lord, that also includes the involvement of the judgment debtor number not appearing. Now, just the settlement between judgment debtor number 1 and the decree holder might create some problem. My lord, kindly keep this matter after the
Okay,
lecture
learned
and
advocates for the decree holder and learned advocate for judgment debtor number 1 are present. As talks of settlements are going on, let this matter appear on 17/6/2025.
Lordship, the matter is very fundamentally very simple. That in the settlement, the judgment debtors were asked to execute no objection certificates in favor which were in respect of the transfer
If
of shares.
settlement fails, consequential order will follow. 17/6.
Faithful.
And my lord, if the judgment direction could be passed for service upon the judgment debtor number 2, which not everybody has participated, that might create a problem for the settlement itself. The judgment debtor number 2 does not approve. My lord, kindly grants, directs them to serve judgment debtor number 2 again, so that if he wants to
The
appeal.
service is already there.
I do not know, my lord. Decree holder has served upon the judgment debtor. I have received service, my lord, that's why.
Anyway, so
Just
you issue notice upon them so that they appear in the
Settlement involved all parties.
Yes, yes.
Even if they serve, we can serve once again, we'll try our luck, because otherwise this matter will never end because of the absence of one of the parties.
We shall solve it.
Okay, in the meantime, service must be caused upon judgment debtor number 2.
I'm extremely grateful to you.
Okay.
mentioning if any.
This is for extension. It is appearing at our instance, Your Lordship. This is a matter pertaining to the determination of Justice Sugata Majumdar. But there's an interim order which is till today, Madam. So we had mentioned for defendant.
For the intervener, Lordship.
I am for the defendant. But if Your Lordship kindly permits.
Give the order. When is last order?
22nd.
Yes, record an order. Learned advocate for the plaintiff, learned advocate for the defendant, and learned advocate for the intervener are present. It appears from order dated 22nd April 2025, passed by His Lordship Honorable Justice Sugata Majumdar, that the interim order is till 20th May 2025. Stop. Thus, the interim order stands extended for a period of 1 week after vacation.
Would Your Lordship specify a date till which is extended, my Lord?
You mentioned the matter.
Grateful. Same matter. Same matter. 13 and 14.
Same order.
Same.
Okay, item number 14 also same order.
But I appear, Honor. But here, Bala, there were certain issues with regard to the number of the PLA. The PLA number, actual number is PLA 102A of 1993. However, Bala, it has been in the cause list, it has been numbered as PLA 102.
Because 102A হচ্ছে নিচ্ছে না ওখানে
The-
because
That has to be
CIS
rectified.
Yes, but that has to be rectified even in the CIS. And the CIS also doesn't reflect the central filing section also does not reflect.
Any order was passed on the last occasion on this matter.
Yes, Manoj, on the last occasion, Lordship had passed this order. There are certain typographical errors. Manoj, one is, Manoj, may I indicate I've made the corrections by hand if your Lordship doesn't mind, Manoj, may I? But first is at the top, before the cause title, PLA 102A. Could be PLA 102A of 1993.
one of the trustees of Chimandal Bhartiya Trust.
And Manoj, on the first line of the order, learned advocate for the executor is present. Manoj, it would be one of the trustees of the trust formed under the will. But this was perhaps due to our wrong submission that it was recorded on the executor.
Chimanlal Bhatia Trust.
Yes, Chimanlal Bhartiya Trust. This trust has been formed under the will. Now I am one of the trustees of the trust.
And one of the trustees, okay. Yes, record an order. Learned advocate appearing for the petitioner trustees in PLA 102 capital A of 1993 is present. Hundred and 2A is not appearing today.
Yes, Manoj, that is the issue because 102A is not even there in the central filing section. And the CIS also does not.
Papers are of 102A, but the
No, this order ought to have been passed in 102A.
Yes, Manoj.
Okay. But PLA 102A is not appearing in the cause list, and it is submitted by the learned advocate that it is not appearing in the CIS file, CIS.
CIS and the central filing section.
CIS.
102A তে list এ
Although
হ্যাঁ আছে
order was passed on in PLA 102 of 1993, but it is submitted by the learned advocate that such prayer was made in PLA 102A of 1993. In the facts and circumstances, let a report be submitted by the register original site as to why PLA 102A is not registered and not appearing in CIS. Let a report be submitted on or before 13/6/2025.
The time to file the Wakalatnama may be extended, my lordship. In
The
102.
Vokalatnama, the time to file Vokalatnama is extended till 23/5/2025.
In 102A. In 102.
In 102A.
Fileটা কিসের এসেছে? 102A এর file চলে এসেছে তো? হ্যাঁ। Great. Well, the records of 102A
Okay,
are available.
102A is treated in the days list.
Yes,
102A, PLA 102A is treated in the days list.
সার্টিফিকেট কপিটা অ্যাপ্লাই করলে যাতে এটা সেটা যাতে
এটা তো করা আছে extend করা।
এটা বলে দাও trigger to হচ্ছে PLA 102A
But I'm sorry, my lord, one more correction is that, my lord, since your lordship has
No, I have not corrected anything. I have just asked the register to submit a report.
Yes, my lord, leave to file Wakalatnama has been, the time has been extended. If you'll, I'll file the Wakalatnama, and once I file for the certified copy of all the records, my lordship,
So that is why you just wait for some time. Let a report come.
wait.
Otherwise, entire thing will be confused.
I'll come back. My lord, on 13th June, it's
13.
returned.
On or before 13.
And the matter is made returnable on 13th. Grateful, my lord.
I am but the petitioner.
Yes, sir. This matter, some clarification was
No,
not
no,
for.
this is not for clarification, my lord. Your lordship was, my lord, after hearing, my lord, this matter has been fixed for order.
Let me see. No, one of your matters is disposed. One of this suit properties.
Yes, yes.
That is one application is disposed.
Yes.
So these two applications to be disposed.
Yes, to be disposed.
So let me see the record. চেম্বারে আচ্ছা তাহলে এটা একটু রেকর্ড করে নিন, নটা অর্ডার রেকর্ড করে নিন। Learned advocates for the parties are present. Are learned advocates. Let this matter appear for orders on. I'm keeping it for orders after vacation.
Yes, yes.
For orders on 11/6/2025.
16 and 17, my lord. 17 is also same.
Yes, both. 17.
I am for the applicant in GO4, my lord.
So this GA has to be heard out.
It was heard out on the last occasion, my lord.
Let me see. You are representing whom?
Indian Oil Corporation, my lord. Applicant in GO4.
Oh, this is your prayer for amendment of the
Written statement, my lord.
এটা দেখি হ্যাঁ অপোজিশন এটা রিপ্লাই ঠিক আছে on the last occasion the opposite party was present.
Yes, my lord.
Yes, record an order. Learned advocate for the petitioner defendant is present. As this matter was already heard out earlier, let it appear for orders on 23/5/2025. Yes, on 23/5 it will appear for orders. আচ্ছা এইটার সাথে ওই যে মাস্টার সামান্সটা এই মানে নোটিশ অফ মোশনটা দিয়ে চেম্বারে পাঠিয়ে দিতে হবে বলে এইটা দিয়ে আর ওই এটার সাথে যে নোটিশ অফ মোশনটা আছে দিয়ে চেম্বারে আর এই দুটো রেকর্ড কি চেম্বারে আছে নাকি 16 আর 17? ঠিক আছে 16-17 তো ছুটির পরে হবে, এটা 23/5।
This matter I am
Is my application for the amendment matter.
Yes, yes, I've heard out the matter.
Yes. My lord, pursuant to Lordship direction, my lord, I am filing the notes of argument.
Yes, I have recorded your submission. I am passing the orders.
My lord, today itself, my lord. But as per your Lordship directions, the notes of argument has been filed today.
Anyway, I shall record that you have filed the notes of arguments. Okay.
I have also handed over the.
Yes, yes, yes. No, your copy I have received. Yes. ওটা পরে আমি ইয়ে করে নেবো দেখে ওটাকে পরে করে let there be an order in terms of prayer B, C, D and E of the master summons dated 27/1/2025 subject to the modification that proposed amendment in item number 15D of written schedule is disallowed. Such order is subject to the payment of costs of 200 GMs within 1 week after vacation.
Within 1 week, man.
Yes, so I have allowed all your prayers except 15D and pay the cost within 1 week after vacation.
Let it be, my lord, 2 weeks after vacation.
Acha, cost within 2 weeks after vacation.
My lord, I am deeply obliged. I am grateful, man.
GA stands disposed. এটা একটু পাঠিয়ে দিতে হবে এই যে এটা হ্যাঁ রিটেন নোটস আর এটা
I am grateful.
Grateful, madam. But the matter will appear for witness action again.
Yes, you mentioned it. Let him pay the cost, take necessary steps.
Well.
Yes, not today.
The lot time for defendant number 1A and 1B.
22.
Plaintiff, my lord. 22 and 23 are, my lord, identical matters. The only difference is, my lord, 23 is for the transposition of the defendants, the application which has been filed by my clients. My lord, my clients are two senior citizen ladies. One aged 85 years, one about 65 years.
What is the suit for?
Suit for partition.
Suit is a partition suit.
So this application is ready for hearing. Affidavits are complete.
My lord, everything is complete. Rather, in fact, the valuation was also being ordered. The property.
No, transposition affidavit.
No, not affidavit is not in the
My lord, there are-
transposition. Preliminary decree was passed. My lord, then the plaintiff came. He interfered with the preliminary decree. Then it was modified accordingly. Then they asked for valuation.
So regarding GA18 is your application.
My lord,
Taken out by the defendant for transposition.
My lord,
No, my lord.
20
GA22 is.
22 is my application.
Yes, taken out
Item
by
number
the
23, my lord.
yes, item 23 GA22 of 2025 is your application. Taken out for the purpose of transposition.
Yes.
So in this application, affidavits are filed.
No. My lord, since the partition suit, all the parties carries the same justice, my lord. Therefore, since it's going on since long, and my lord, defendant number
My
1
lord,
and
the
1.
plaintiff, I appear for the plaintiff, my lord. I am opposing this application, my lord.
So
If
why
I
didn't
may
you file your affidavits if you are opposing?
If my lord.
Anyway, let them file.
His wife substituted him. She's also actually she has to get some sort of relief. Plaintiff is not taking any step.
Who is for the plaintiff?
My lord, I appear for the plaintiff.
I am appearing on behalf
One
of the
of the-
substituted defendant.
Respondent number 4A, B and C.
Defendant number 4A, B and C.
Original, respondent number 4 is that, but not,
What happens, my lord? I shall take one minute more, my lord. My lord, 1 minute more, my lord. Already, my lord, preliminary decree has already been passed. Court observed that there is no provision for meets and bonds partition. There is no provision, no why. So, my lord, court directed to appoint a valuer and to get the value, and after selling, proceeds can be distributed as per their share. That's all, my lord. So one application has been filed for appointing a valuer and one application is filed for transposition. So at least transposition may be allowed, my lord. Otherwise, matter will not move, my lord.
My lord, that, my lord, if my lord directs affidavits, then my lord, let
My
that
lord,
be.
otherwise also I want to submit one thing. My lord, since who's the original plaintiff now? My learned friend. My lord, defendant number 567 happens to be the sons of the original plaintiff. So, my lord, they are in collusion. And my lord, all the advocates on record have been appointed as the receiver in this matter. My lord, the preliminary decree was passed on 24th of July 2014, my lord. My lord, if I may just place the last portion of that preliminary decree, my lord, it says that in the event the plaintiff is unable to bear any of the costs, expenses, and fees required to be incurred to implement this order, the modification made herein shall stand recalled forthwith. My lord, there was an interference by the original plaintiff to modify the preliminary decree which was passed long back in 2014. Thereafter, my lord, they have not done anything with this. And my lord, we all are suffering.
Now this application is to be taken up regarding transposition and appointment of valuer.
My lord, as far as valuation is concerned, my lord, they are not opposing to that. And second, my lord, transposition, why I am insisting upon, my lord, I am ready to bear.
So let the valuation application be allowed.
My lord, that can be done.
So who is to appoint the valuer? All the plaintiffs who are appointed.
All the advocates on record are there, my lord.
So, yes. No valuer appointed today. So let me appoint a special officer who will appoint a valuer.
My lord, rather in the order, my lord, it says that all the advocates on record are appointed as the
How these advocates cannot sit and take a decision with regard to appointment of valuer.
Right, my lord, the plaintiff advocate record.
So better appoint a special officer.
My lord.
Yes. Learned advocate for the
valuer itself.
Learned advocate for the plaintiff.
The valuer.
You are for?
My lord, I am for defendant number 1 and 1.
Learned advocate for defendant number
1A and 1B.
1A and 1B. You are for?
I'm for 4A, B, and C.
Learned advocate for defendant number 4A, B, and C. You are?
I'm for the defendant number 5, 6, and 7.
Learned advocate for defendant number 5, 6, and 7. You?
Substitute defendant number 2A, 2B, 2C.
Learned advocate for defendant number 2A, 2B, 2C. You?
Appearing, my lord, on behalf of the defendant number 3A, 3B, and 3C.
Learned advocate for defendant number 3A, 3B, and 3C are present. This application GA 22 of 2025 is taken up for consideration. As this GA 22 of 2025 is for transposition, the matter should be heard upon granting opportunity to the parties to file affidavits. Let affidavits be filed by 10/6/2025 and reply, if any, by 13/6/2025. Let this matter appear on 16/6/2025. Now, stop. This is with regard to item number 23.
Yes, my lord.
This is regard to item number 23. Yes,
23,
item 22 ever. Item 22 এর রেকর্ডটা দেখি একটু। GA 22 GA 22
is item 20
হলো এবার GA 18 টা একটু দিন।
My lord, GA 18 is also my application by defendant number 1 and 1B for appointment of valuer.
Yes, GA 18. এটা তো GA 22 আছে, নিচেরটা কত? 22. Yes, you have any copy of GA 18 records?
We shall hand up.
It's a marked copy. Anyway, if you have a spare copy, please give me.
My lord, I shall get it photocopied and my lord, I shall hand it.
This is also marked.
Marked,
Lordship,
but
will-
my lord,
will
only the
ignore.
page numbers is being marked.
GA 18 of 2023 is filed by defendant number 2A.
My lord, 1A and 1B.
1A and 1B for appointment of valuer as directed by order dated May 13, 2015. Stop. As the learned advocates on record for the plaintiffs, for the parties are appointed as receivers who are to take steps for appointment of valuer, but such appointment is not made in the meantime, this court is of the view that a special officer should be appointed who should appoint a valuer and obtain a report from the said valuer and file the same.
If my lord can appoint a valuer itself, my lord. My lord can appoint a valuer itself.
It's better why the court should take it. I'm doing it through Dash is appointed as a special officer who shall take steps upon discussion with the parties to appoint a valuer. In the event the parties do not agree, the learned special officer shall use his discretion and appoint a valuer. Upon the valuer's fees shall be paid by the parties in accordance with the shares. Upon obtaining the valuer's report, learned special officer shall submit his own report enclosing the report of the valuer.
Time may be fixed.
Yes. Such exercise, the remuneration of the learned special officer is fixed as dash. The time to submit the report by the valuer is time to submit the report by the special officer is fixed on 16/6/2025. Let this matter appear on 16/6/2025.
All parties in equal proportion.
Actually, maybe, but as because they are unable to agree with regard to valuation, I'm left the matter to a special officer who shall appoint the valuer and submit his own report as well as the valuation report.
And in fact, my lord, even the valuation thing is also pending since May 13, 2015's order.
Anyway, let it be done.
My lord. Grateful. I'm for the plaintiff. But in this matter, there are two GS pending. GA 8 is a GA filed by the learned receiver appointed in the suit. And GA 11 has been filed by the defendants for their transposition in place of the plaintiff.
Who is for the defendant?
When they are not appearing, they are not appearing.
Okay, let it be not today then.
Lord will kindly keep it after holidays. I will serve them a notice, otherwise they will
Okay.
not come.
Item learned advocate for the plaintiff is present. None appears for the defendant. The matter stands adjourned till 11/6/2025.
Lord, direct me to serve notice.
Yes, let notice be served upon the defendant.
And the receiver.
Let the notice be served upon the defendant and the receiver.
I'm grateful. Lord.
This is my application for revocation of the grant of letters of administration. Lord, in terms of your lordship's last order, we have prepared the notes.
Yes, yes.
My lord, the engrossed copy is not yet here, my lord. I'm placing the notes from my copy. In the meantime, they're getting the engrossed copy, my lord. I'll just indicate what are the facts, my lord. This was argued on the last occasion, my lord. So, my lord, the applicant before your lordship is the daughter of, my lord, the erstwhile king's executor, the
The applicant before your lordship is, my lord, the sister of is the daughter of, my lord, the executor of the will of the last king of Panchkot Raj. My lord, in 1956, 8th of January 1956, the last king of Panchkot Raj, which is in Purulia, my lord, inherited the entire estate from his father following the rule of primogeniture. In 1956, my lord, 17th of July, the Hindu Succession Act came into force, 17th of June.
Yes.
When the succession opened, on that day, my lord, the Hindu Succession Act was not in force. So, my lord, following the custom of the family, rule of primogeniture.
Under the old Hindu law?
Yes, my lord. It came through into the eldest son, and accordingly, Bhuvaneshwari Prasad Singh Deo, the last king, inherited the estate. Now, in terms of the last will of the said Bhuvaneshwari Prasad Singh Deo, which is of 9th of November 1970, he has distributed the estate in his will, which is pending, my lord, grant of probate. Initially, there was a grant, and thereafter it was revoked by way of withdrawal. And again, now it's been applied for the grant. My lord, the applicant, my lord, I'm just handing over my copy for the timing so that your lordship can have a look at it. There's a list of dates we have prepared along with, my lord, the notes which is following the list of dates. My lord, if your lordship sees the third entry, 9th November 1970, Bhuvaneshwari Prasad Singh Deo during his lifetime published his last will and testament and appointed, my lord, Ranjit Kumar Singh Deo as the executor of the will. And in his absence, his major son. My lord, in 72, Bhuvaneshwari Prasad Singh Deo passed away. In 1987, my lord, Ranjit Kumar Singh Deo applied for grant of probate. My lord, the probate was initially granted. And my lord, on 14th September 1987, probate of the last will and testament of Bhuvaneshwari Prasad Singh Deo was granted in favor of Ranjit Kumar Singh Deo. My lord, on March 29, 1988, the inventory and accounts of the estate was filed before this honorable court by Ranjit Kumar Singh Deo. However, my lord, in 1992, Maheshwari Devi, who is, my lord, the sister of Bhuvaneshwari Prasad Singh Deo, files an application for revocation of the grant. There are certain issues, my lord, which is pending with regards to that. My lord, Maheshwari Devi, as an imposter, and also brings forward, my lord, a person to impersonate Ranjit Kumar Singh Deo. And accordingly,
the application was made originally by Ranjit Kumar Singh.
Yes, my lord.
And subsequently, for the grant of revocation, one person was impersonated.
Yes, my lord.
To represent Ranjit Kumar
Yes,
Singh.
my lord.
That is the executor.
That is the executor. Now, after that, what has happened? The will was, the application for grant was withdrawn. Thereafter, my lord, we have now again come up with an application for grant of the probate. It is at this stage, my lord, we also came to learn of this. The applicant before your lordship is the daughter of Ranjit Kumar Singh Deo, who was not aware of all these proceedings, but she, as the heir of my lord Ranjit Kumar Singh Deo, is also has a covetable interest. So, my lord, she
during 1970s and all these things, this Indian Succession Act was there.
Yes, my lord.
So Bhuvaneshwari Singh Deo passed away, and 9/11/1970, the
Yes.
will was executed. 72, she passed away.
He passed away.
And Ranjit Kumar Singh Deo applied and obtained the grant. And thereafter, it was revoked.
Yes, my lord.
In 90, that is
in 97. 1997.
Okay. 100?
94, 97.
Oh, filed an application for letters of administration.
This is the letters of administration, which is now, of which I now seek revocation.
No, that original grant of probate goes.
Original grant of probate is gone.
By that revocation order.
Yes, my lord.
Now, again, this Maheshwari Devi applied for letters of administration.
For letters of administration.
Of the estate of Durgesh Devi.
Yes. Now, Durgesh Devi was the mother of Maheshwari Devi and my lord Bhuvaneshwari Prasad Singh Deo.
Yes.
In the will, my lord, because, my lord, the entire estate vested with Bhuvaneshwari Prasad Singh Deo way back in, my lord, 1956, 8th of January, when Bhuvaneshwari Prasad Singh Deo's father passed away, prior to the Hindu Succession Act as it's today coming into force. So
1956 Hindu Succession Act came into force.
my lord, 1956 Hindu Succession Act comes into force on 17th June.
And her father passed away.
His father passed away on 8th January.
8th January.
So the estate vested in Bhuvaneshwari Prasad Singh Deo. Before, my lord, 56 Act comes into force, the succession opened and it completely vested with the last king, to the son, eldest son.
Yes.
So, my lord, Durgesh Devi, whose letters of administration to whose estate has been obtained by Maheshwari Devi, Durgesh Devi had limited rights as indicated in the will of Bhuvaneshwari Prasad Singh Deo. Whereas, my lord, Maheshwari Devi comes forward to this court and applies as if Durgesh Devi has a substantial right over the entire estate. Suppresses the will in the application. So as a consequence,
it was obtained.
Yes. In 1997, 24th June, my lord, the grant was obtained.
Yes.
So they applied, and my lord, on June 8, 2016, the grant was given. That is the third last entry in the note, my lord. Maheshwari Devi applied in 1997. And grant is of 2016.
So 24/6/1997, that is Maheshwari Devi applied for
Yes, my
letters of administration. Then application for recalling was filed by Abhijit Singh Deo.
That is to the application for grant of probate to the will.
Okay. No,
Which was
that
withdrawn.
Probate, the grant of probate was revoked.
Yes.
So that revocation order was prayed to be set aside.
Yes, my lord.
That is by Abhijit Singh Deo.
Yes, my lord.
He prayed to set aside that order.
Yes, my lord. He prayed and it was declined.
So that setting aside order prayer was refused.
Yes, my lord. It was refused.
Setting aside of the revocation order.
Yes, my lord. It was setting aside of the revocation was refused.
Yes.
So, my lord.
So that revocation remained.
Revocation remained. But when the will also remains.
Yes, if revocation remains, the will remains.
Will remains.
That means the will which is filed in the court, that will.
Yes, that has not yet been probated.
Probate is sought for, that has to be probated.
That is now pending before the coordinate bench.
Yes.
Which is, my lord, if your lordship sees, 2021. Manojit Singh Deo filed fresh application for grant of probate of the last will and testament.
2021.
Yes, my lord, which is the second last entry.
Probate of the last will, Bhuvaneshwari Prasad Singh Deo.
Yes, my lord. So, my lord, what happened was initially applied for grant of probate by Ranjit Singh Deo. Ranjit Singh Deo granted probate granted in favor of Ranjit Singh Deo. Maheshwari Prasad Singh Deo impersonates someone, brings someone as Ranjit Singh Deo, has the probate revoked without contest. Ultimately, she has the application for grant of probate withdrawn.
No, when the probate was granted, this Ranjit Singh Deo came. Not Ranjit Singh Deo came.
Whosoever
he was impersonated.
Yes, my lord.
And the application for revocation of probate was allowed.
Yes.
Then subsequently, this person, that is Ranjit Singh, not Ranjit Singh,
His eldest son, Abhijit Singh Deo, applied
to set aside
for recalling of the order.
That means to
setting aside for the grant of revocation.
Yes, that revocation order be set aside.
Yes.
So that was not allowed.
That was not allowed.
So if that revocation order remains, that means the probate also remains to be, the will also remains.
Will remains.
To be probated.
Yes, my lord.
Now in the meantime, Maheshwari Devi has also filed another application.
Yes.
PLA 115.
In which, my lord, she was granted letters of administration of the estate.
So that is still continuing.
This is the application which your lordship is hearing. So the letters of administration which Maheshwari Devi applied for of the estate of Durgesh Devi, to that we are seeking revocation of that letters of administration.
Because that probate case was suppressed.
Yes, probate suppressed, and my lord, if the will is suppressed in the application, so my lord, any person who has any benefit under the will has a caveatable interest, because in the event my lord the will is probated, that person gains a right. So my lord, no citation served.
Probate has to be given effect, whatever
Yes,
rightly or wrongly,
yes.
whatever.
So we have applied for that grant of probate.
No, probate application, that probate case, that is testamentary suit is still pending.
That is still pending. We have filed it afresh.
Because no, you have filed the one application, that suit is pending for grant of probate.
No, I'll indicate, my lord, if your lordship sees what happened. In 97, my lord, I'm sorry, on 28th March 1994, if your lordship sees, this is entry number.
Yes, 28/3/1984.
Yes, my lord. Lordship will kindly see, there's
Yes,
an order of this court which records this. My lord, Justice Babulal Jain's order, learned counsel on behalf of Sri Ranjit Kumar Singh Dev prayed for leave to withdraw petition.
Right. That probate application.
That was also withdrawn, which is under extremely suspicious circumstances.
Revocation order is not set aside.
Right.
That suit remains.
Right.
Will remains.
Right.
But if that probate application is withdrawn, then nothing remains.
Nothing remains. So as a result,
happened to that?
So it was withdrawn. Lordship will see, my lord, the order further records that the executor Ranjit Kumar Singh Dev, now deceased, was identified by one Shaurendra Narayan Singh Dev, who was related to the executor from his father's side, as his father was one of the cousins of the executor. Court accordingly dismissed the application for grant of probate applied by the executor as not pressed. If your lordship sees this order of 94.
Yes, because this executor, original executor was this Ranjit Kumar Singh.
Yes, my lord.
Singh Dev. And this application, the probate application was withdrawn by this Shaurendra Narayan.
What happened, my lord, the circumstances are such, Ranjit Singh Dev gets probate.
One person was impersonated as
as Ranjit Singh Dev,
probate
and
was that revoked.
on his consent, probate is revoked.
Yes,
and
but the
again,
application suit
right.
remains.
So suit remains. So Maheshwari Devi realizes that the suit remains. What they do, they get somebody else and says that yes, that person is Ranjit Singh Dev, and withdraws the suit.
So that application was withdrawn by stating that by claiming himself as Ranjit Singh Dev.
Yes, my lord. This is page 49 to 52. This is the order.
Page 49.
At page 52, 50, my lord.
50. That is, this order is passed in?
My lord, this is passed in PLA number 138 of 1987.
No, page 50 of your?
50.
50?
Yes, my lord.
This statement of accounts.
Lord, you will kindly see, my lord. Hands possession deciding. I'm so sorry, my lord. I'm so sorry. It's not page 50. That is statement of accounts. I'll just a minute, my lord. Yes, my lord. This is at page 54. I'm so sorry.
54.
Learned counsel appearing on behalf of Ranjit Singh Dev prays for leave to withdraw petition made by his client for grant of probate. Mr. Mullik, learned counsel on behalf of the petitioner, wants to examine his client in court and has done so. He also wanted his client to be identified by Shaurendra Narayan Singh Dev, who has deposed before this court, and identified the petitioner Ranjit Kumar Singh Dev. Representative of Srimati Maheshwari Devi, who claims to be the heir, at whose instance the earlier ex parte order for grant of probate as made in the above proceeding was recalled and set aside, is also present in court and has also been examined on behalf of Srimati Maheshwari Devi. He has also identified the petitioner. The learned advocate on behalf of the petitioner Ranjit Kumar Singh Dev has also submitted before this court that the petitioner who has deposed is his client, though it was, I can't read it, though it was an inquiry that was started. However, I am satisfied as to the identity of the petitioner It has been submitted on behalf of the petitioner. The petitioner has also deposed that he does not want to press the application and does not wish to propound the alleged will.
Yes, so this is the order.
Yes, my lord. The application, my lord, there are the order is annexed twice over because, my lord,
It is not
first,
pressed.
yes, my lord. If your
It is
lordship turns,
dismissed as not pressed.
yes, my lord. If your lordship turns to page 57,
Yes.
it is there. The application, therefore, is dismissed as not pressed. Parties will be at liberty to obtain Xerox certified copy. Learned advocate may draw up and complete. So, my lord, the probate is withdrawn. Application. We apply afresh. Well, the next page is the application filed by Abhijit Singh Deo seeking
So
recalling.
Any you have documents you have to show that this Ranjit Singh Deo died when this order was passed.
No, my lord. Ranjit Singh Deo died after that.
After this order is passed.
Yes, yes, my lord. It was after. But he was not present in court.
No, suppose if you can show that he died before that, then definitely the
It will become
case comes to an end.
So that is in the probate proceeding, my lord. He died on 28th of August, 1996. And this order is of 94. So, my lord, his eldest son applied, which is Abhijit Singh Deo, for recalling, which was not allowed.
Recalling of which order?
Recalling of the order by which, my lord,
That it was dismissed for non-prosecution.
yes, my lord.
Where is that order refusing that recalling?
That's at page 59.
59. Yes. 59, yes.
Well, the last paragraph at 59, this is an application allegedly filed by the son of Ranjit Singh Deo, verified by a constitutional attorney, almost 20 years after the order dated 28th of March 1994. The inordinate delay cannot be condoned as there is no sufficient explanation for this. Even on merits, this application cannot be entertained. Petitioner wants revival of the probate proceedings. He says that as the heir of Ranjit Kumar Singh Deo, he has acquired an interest in the estate. Ranjit Kumar Singh Deo is dead. In no way can the petitioner revive the probate proceedings taken out by him as the propounder, especially after withdrawal of the same by Ranjit Singh Deo, which withdrawal has attained finality. For all those reasons, application is dismissed. There is no.
Now the question is, you see, if you are not allowed to recall that order, can you file afresh? That is the question.
Now, my lord, if what has happened,
because this order is not taken up in appeal
no,
also.
No, it's not taken up.
So now the question is, because your remedy was to get that order recalled, but because obtained by fraud.
Yes.
So that was not accepted. So that order remains.
That order remains. Now I'll just
What
indicate,
is-
my lord, the probate proceeding. So, my lord, the will is there. The will is unprobated. And the will is, as on date, my lord, in terms of the will, I'll show your lordship the will. In terms of the will, it has to be probated by either Ranjit Singh Deo or his eldest surviving son. Your lordship takes page 28.
Oh, very well. That whatever is stated in the terms of the will, that has to be complied.
Yes, my lord.
But the question is, you see, once a thing is withdrawn and your prayer to set aside that or recall that is disallowed, that has reached its finality, how can you file?
So, my lord, that is a separate proceeding. Now, before your lordship is the application by the daughter of Ranjit Singh Deo seeking revocation of the letters of administration granted to Maheshwari Devi.
Oh, that can be taken up.
Yes, my lord.
That there is no bar.
So that is the application which we are agitating before your lordship. So we have served them twice over. They have not appeared.
Yes, what is the order? Granting letter of administration?
Yes, my lord. That letter, that order is of, my lord, 2016, which is at page Wait. See. So this is at page 98, my lord.
Page 98. PLA is disposed of.
Yes, my lord. This is the order of grant.
Yes.
And the grant is at page 99. 99 and 100. Well, the handwritten copy is there, followed by, my lord, the type copy.
Yes.
So that is the grant, my lord.
There some directions are also issued.
Yes, my lord.
To make full and true inventory. Was there any compliance with regard to
Nothing
that?
fine. So, my lord, because I'll indicate we couldn't trace out all the records we applied before this court. That order is there of 2019. If your lordship is pleased to turn to page 85. 3rd July 2019. It appears that the petitioner had filed an requisition for various documents and orders passed by this court. However, department has placed the court orders. Accordingly, department is directed to provide the petitioner with certified copies and photocopies of the orders dated such and such, passed in such and such. With the above direction, GA is disposed of. So we have only got orders relating to, my lord, the grant application for grant of probate. With regards to the application where, my lord,
No other report is there regarding.
Nothing is there. So, my lord, as of now, we have also applied for the grant of probate of the will, which is before the other bench.
Anyway, so far this court is concerned, so I am before, I am to dispose this PLA 115 of.
Yes, my lord.
1997, that is GA 14.
This is GA 14 where I have sought
revocation
of the grant.
In PLA 115 of
Yes,
1997.
my lord. Which is PLA 115 is the application for grant of letters of administration to the estate of Durgesh Devi.
So, which according to you is obtained by fraud?
Yes, because there was no, they didn't issue a citation on us.
Your ground is you are not intimated and suppression of facts.
Yes, my lord.
And any impersonation?
No, in this there is no impersonation.
No, one person who is appearing as a Ranjit Singh. This
That is in the probate proceeding.
No, in this case or in this
No,
case?
not in this case. This is for
in probate proceedings, yes.
Which was withdrawn by allegedly by Ranjit Singh. What we have applied there, my lord.
And it is suppression of material facts.
Here this is separate because citation not issued on the heirs of my lord Ranjit Singh Dev. The applicant before your lordships in the letters of the administration proceeding was aware that there's a probate proceeding pending. she was aware that Ranjit Singh Dev is the executor. She was aware that there is a will, because otherwise she couldn't have applied for revocation. So naturally, everyone who would have gained anything upon the demise of Ranjit Singh Dev should have been cited. There is no citation.
And the applicant before this court is the son of
Is the daughter
of Ranjit.
Ranjit Singh Dev.
Ranjit Singh Dev had some interest in the
Was the executor of the will.
no executor as well as some
and the
beneficiary. So this applicant has some interest in the
estate of Ranjit Singh Dev as well as Bhuvaneshwari Prasad Singh Dev.
yes. So this is on the grounds of fraud you have
Yes, my lord.
challenged.
Paragraph 40, I have pleaded fraud. And my lord,
Yes.
I have also indicated as to when I came to learn of this, my lord.
Yes. Where have you stayed? When?
Yes, my lord. Paragraph 8, if your lordship sees.
Yes.
8, 9, and 10. This is when I came to learn. 17th December 2024.
Yes.
And my lord, the grounds of fraud at paragraph 34.
Yes.
Regarding how fraudulently the probate was withdrawn. That has also been pleaded, paragraph 34.
Yes.
Paragraph 35, I've pleaded that in the meantime, Maheshwari Devi applied for grant of letters of administration. So this is the case, my lord, that has been made out.
So you served upon
I have served upon Maheshwari Devi.
Maheshwari Devi, the applicant of this
Yes,
PLA.
the applicant in PLA. It has come back as refused. So the application and the affidavit of service, everything is there, my lord.
Yes, anything else to add?
No, my lord, that is all, my lord. These are my respectful submission. My lord, lordship grants me time till the end of day. I'll put in the notes, my lord. This is a
back this one.
Yes, well, same. It will be the same note. It will be in the engrossed form, my lord, because the court's record should reflect correctly, my lord.
Learned, Mr. Ghosh, learned advocate for the applicant is present. Our learned advocate on GA number 14 of 2025. None appears for the petitioner ELA number 150 of 1997 in spite of issuance of notice, as the envelope has returned with the remark refused, and refused is a good and refusal is a good service. Thus, this application is taken up for hearing. Heard learned advocates. Hearing is concluded. Let this matter appear for orders on 17/6/2025.
Great.
Let the written, shall I record written notes?
Yes, yes, my lord.
Filed.
Lord, in course of the day, my lord, if you
Okay,
lordship.
let written notes of argument be filed in course of the day.
Lordship. Great. এটা কপি দিয়েছি না ওটা একটু আমায় দিয়ে দাও।
Petitioner in PLA number 115. Yes, petitioner Maheshwari Devi করে দিন। Maheshwari Devi. Petitioner in PLA number 115 of 1997.
Great.
Yes.
Testamental matter item number 26 in the group of Sunil Kumar Chakraborty.
Yes, not today.
27 in the group of Pokrit Chat Nahata.
Not today.
28 in the group of Ashafian.
Not today. ঠিক আছে, এখন থাক, ওই ছুটির পরে একটা মানে এবারে একটা নোটিশ দিতে হবে আর কি। কালকে যদি না অ্যাপিয়ার করে তাহলে ছুটির পরে একটা ডেট দিয়ে লাস্ট চান্স করতে হবে।
Item number 29, Bilashpur Casting.
রেকর্ড অর্ডারটা দেখি আগের দিনের। মানে 23/4 অর্ডারটা। আচ্ছা, রেকর্ড করুন। None appears for the parties when the matter is called. Let this matter appear on 13/6/2025.
Item number 30, Hemant Beg.
Yes.
My lord, I am
Lordship was pleased to adjourn GA 12 and 13 on 17 June. Today, my lord, I am pressing GA 14 and 15.
GA 14 and 15.
Yes, my learned friend is appearing for the erstwhile receiver. He is not concerned with GA 14 or 15.
No, you are moving GA 15.
But GA 14 and 15.
Yes, GA 14 is for?
Lord, the original title deeds of this property, subject matter of the partition suit, were, my lord, deposited with a third party. Record nahi asheni? Lord, that woman died subsequently. Lord, after I stepped into the shoes of the receiver, I am the plaintiff, sole plaintiff. I was appointed the receiver in place and instead of the erstwhile receiver. After I stepped into the shoes of the erstwhile receiver, I searched the records and I didn't find the title deeds. Then, my lord, it transpired that the title deeds were kept with the third party. I tried to contact that third party. She was dead. I contacted her heirs. Now, my lord, after I took out this application,
The records are not here.
I'm told records have come.
Record আসেনি। আচ্ছা, let this matter Then, my lord, may I come back tomorrow? There is some urgency. Let this matter appear on. Anyway, Thursday I'm keeping. Thursday, very good. Let it appear on 22/5/2025. Let the records must be put up on the said date. Grateful.
And I am for the erstwhile receiver GA13 be excluded. In the last order, it is supposed to appear on the 17th.
Both GA12 and
So-
13 may appear on that date. Yes, yes, that will be taken up on that
Adjourned
date.
date. Very good.
But I am taking up this G14 and 15.
15. Lordship.
Grateful.
Item number 31, Lakshmi Devi, Nathani and others.
Yes, not today.
32, Shita Banerjee.
Yes, not today.
33, 21st century.
Not today.
34, GT and Company.
Not today.
35, Virendra Sanghi. 36, Rajasthan Exclusive.
Lordship.
Yes, 36.
Yes, Your Lordship.
Yes.
Your Lordship, I had paid a similar, for a similar matter on the
No, you are
Friday.
appearing for
I'm for the plaintiff.
item 36.
Yes.
Yes.
I had prayed for an adjournment because of the electricity issue in our chamber. We are unable to trace the files at this moment, Your Lordship. The 6-fold post office rate, you have the idea, Your Lordship.
Yes, item 36 on the prayer of learned.
Similarly, I had kept a matter on 18th June on Friday.
On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 18/6/2025.
Item number 37.
I am for the defendant, Your Lordship.
Item 37.
Yes, Your. I am for the defendant, and the matter had been mentioned, my lord, at our behest. This
Yes.
is a suit of 2008, my lord, seeking declaration, and no steps have been taken in the matter after filing of written statement, my lord, by the plaintiff. Now, what has happened, Your Lordship? An interim application was filed. Therein, a direction was given to 9 members of the Tenants Association. This is with regards to a property where the plaintiff is claiming that the rent that I was receiving, he is also entitled to half share of that. So since that rent was the subject matter, there was a direction that the rents by the Tenants Association will be deposited before the registrar original site. So what is happening due to this pendency, my lord, a substantial amount is held up in this matter, my lord. And there are other tenants also outside these 9 members, my lord, who are also refusing to pay the rent. Your Lordship, I am seeking dismissal of this suit. Your
I appear. You are appearing for?
No, I am not. I am defendant number 1. This
You are
is
for?
I appear on behalf of the pro forma defendant, but I am the successor, the assignee of the defendant.
No, no. Who is
I
representing?
am led by Mr. Orunima Lala, who is now the online.
I'm for the defendant number 1, Your.
You are appearing for defendant number 1.
The Orunima Lala is.
No, plaintiff is not represented.
Plaintiff is not
Plaintiff
represented.
is not represented. Suit is pending for a long time, Your Lordship. I'm seeking dismissal of the suit.
Well, may I please submit only one thing? I am appearing on behalf of the pro forma defendant.
You are supporting the plaintiff?
No, my lord. I am the added defendant, pro forma added defendant. My lord, the right title and interest of the defendant number 1 has been assigned to me in 2014.
Okay.
For whom my learned friend is appearing, that has been assigned to me. But subsequently, my client, my client's predecessors, Space Resort, they were added as a pro forma defendant. And then I made an application subsequent to amalgamation of Space Seafood and my client, took out an application for substitution of my name. That has been allowed.
So, but the defendant number 1's name is not deleted.
Not deleted, because the claim that was made in the plane was prior to my assignment.
Right.
The whatever the rent that has been collected and
so whatever is that, the right remains.
Up to 2014, when my property was transferred to me.
After 2014, you acquired some right.
I acquired right, the entire right of the defendant number 1. But only one difficulty I'm facing, I must tell you, Lordship. But in this matter, we obtained a change from the erstwhile advocate on record, Mukherjee Agarwal and Company. The change was obtained, but the Vakalatnama, change the Vakalatnama was filed in 1GA, 1261, not in suit.
Not in this suit.
Not in the suit, but in the application connected with the suit. No, I have already written a letter to the registrar, but to treat the said Vakalatnama is a Vakalatnama in the main suit. Because now, my lord, it's very difficult to get me change from Mukherjee Agarwal and Company. Their office is closed.
You obtain Vokalatnama from your client and with the leave you
But
can
that can be called. Lordship, kindly grant me leave. I can file.
No, you file it. You obtain it and thereafter you obtain leave.
Very well.
You obtain it and thereafter you take
Very
leave.
well. Very well.
Yes.
Very well.
Learned.
Look, today seeking dismissal because this suit has been pending and the plaintiff is not taking steps. Carriage of proceedings is upon the plaintiff, my lord. We are all
The defendant number 1 and learned advocate for the pro forma defendant are present. None appears for the plaintiff. It is submitted by the learned advocate for the defendant number 1.
The name Tarashankar Ganguly.
That the defendants, that the plaintiffs have not taken any steps for a long period. At what stage issues have been framed?
No, no,
nothing, your lordship. Only written statement have been filed. No steps have been taken.
However, in the interest of justice, let this matter appear on 18/6/2025. Learned advocates for the defendant is requested to serve a notice upon the plaintiff and his learned advocate.
Lordship, instead of 18, can it be Lordship the 19 Lordship?
Okay, 19
Lordship. This
6/2025.
Lordship deeply obliged.
Learned advocate for the defendant number 1 is requested to serve notice upon the plaintiff and the learned advocate intimating the next date fixed.
Well, on the pro forma defendant number.
Lordship kindly makes it very
Recorded.
Yes. No, it is a pro forma defendant. There is two defendants. I am the pro forma defendant number 3. Added defendant number 3.
Okay, so learned advocate for the defendant number 1 and defendant number 3.
Your lordship kindly makes this direction peremptory. On the next occasion, we'll seek for dismissal.
Let us see, you serve a notice, okay, intimating the next date fixed.
Grateful, your lordship.
Your lordship rises, Lord, may have
My-
indulgence.
Yes.
Lord, this matter notice due to appear anyway, but to appear tomorrow. But as per lordship, this direction, Lord, we have in the meantime not settled this matter. Lord, so could it appear as for settlement at the top tomorrow?
No, this is to appear.
Your lordship's determination and due to appear tomorrow in any event.
No, 21st. Yes, it is due to appear tomorrow.
Yes, so instead of not in a regular, could it appear as for settlement at the top tomorrow, Lord, because both parties have signed, Lord, we have executed the terms.
They've signed it today, your lordship.
They've signed it today, Lord, if it could appear for settlement at the top tomorrow.
Okay, let it appear. Calcutta to be mentioned.
Yes, Lord, we can file in to be mentioned. I'm grateful.
Grateful.
Very grateful.
The next matter, your lordship.
Yes. Come at 2 p.m. Yes, yes, which matter?
The next matter, the next item, your lordship.
Anyway, come at 2 p.m. or day after tomorrow. That official liquidator matter. Anyway, it's not very urgent. You come at 2 p.m. or tomorrow.
Good.
have, my lord, may I have my lord's leave, my lord? I am mentioning upon notice, my lord, in item 6, it was an execution application.
Item 6 of today's list.
Yes, my lord, lordship was pleased to direct my client to file affidavit of assets, my lord, giving 2 days time. My lord, he is from Bombay. I am being very candid, my lord. If lordship gives me 2 weeks after vacation, because we shall not be able to and default, my lord.
You appear on day after tomorrow, I shall hear you, okay?
Very well, very well. My lord, I shall be making that prayer, my lord. I am apprehensive, my lord. It will be a default, and then, my lord, my learned friend will press for, my lord, warrant of arrest.
This is
Try,
indirect.
try to come on day after tomorrow, I shall definitely hear.
Very well.
This is an indirect way of getting a stay of the filing of the affidavit of assets.
Anyway.
They have
No,
not
I am
secured-
not asking,
There is
my
a 3.5
I am bound to comply. I have to file it.
Secure. Let
Let
them
your
decide
learned
it.
senior friend appear on the next.
For correction, with notice of motion.
Correction?
Correction, because
Yes.
Lord,
Slight
mistake.
My lord, I'm seeking to mention a matter, my lord, for my lord, the urgent determination of Justice Mojumdar.
He is not appearing in the list today.
My lord,
Did
it
not
is-
mention in the morning. No, did you mention in the morning?
My lord, I did not mention in the
Anyway,
morning.
Give the slip, it will appear tomorrow.
কমার্শিয়াল কোথায় যাব
একবার পড়েছে কি না নোটিশ অফ মোশনে আগের অর্ডার লিফটটা দিয়ে দিচ্ছি মানে এটা মাস্টার সামর্থ্য করেনি কিন্তু মাস্টার সামর্থ্য শর্ট সার্ভিস এনিওয়ে লিভ ফর শর্ট সার্ভিস
হ্যাঁ urgent determination এই কোটেই
After an order, 75,000, that will be 75,000.
লাস্ট অর্ডারটা দেখো
এনিওয়ে শর্ট সার্ভিস yes call the list
2 p.m.
to be mentioned.
This has come at our since this is a 2022 suit which has been converted into a commercial suit. Into a non-commercial suit. The interim order granted is till 27th of May. That has to be extended.
No, this is Justice Mojumdar.
Yes, yes,
Then?
yes.
No, I actually, this is I am having the determination to hear the urgent matter of Justice Sugato Mojumdar. But
This pertains to Justice Sugato Mojumdar.
Sugato Mojumdar.
Because
appearing, it is parted before whom? Justice Mojumdar or?
no, it is not parted before anybody. This was a suit.
But why it is mentioned parted?
That may be a mistake, but what happened was in 2022, the present suit was filed in the commercial division. Then by an order passed by the division bench on 26th of March 2025, just paragraph page 13, the fourth line from top in page 13. It is really a matter of conversion. It is now required to be heard by the honorable judge in the non-commercial division. I don't know what objection they have to this bench hearing. So this has been since renumbered as CS number 348 of 2025. This was suit of 2022.
Now the question is with regard to interim order, when was that order passed?
Interim orders, this is the order. The order was passed long back. Kindly see this order. Kindly come to, kindly see this order, para 25. The defendant has already filed a written statement and there is no requirement to serve a fresh summons. The learned single judge is required to consider the pleadings already filed in relation to injunction and summary judgment and decide the issues on the basis of such pleadings. The parties are present. The interim order, the plaintiff was enjoying stands vacated by reason of the return of the plaintiff shall continue for a period of 4 weeks as we find the refusal to extend would cause prejudice. To extend it by 4 weeks from 26th of March. Thereafter, the matter was heard by the division bench once again. On 29th of April 2025, Lordship kindly takes a look. This interim order has been reinstated and continued for a period of 4 weeks. So 4 weeks expires.
Is, you see, the order is passed by the Honorable Division Bench. Where is that liberty that after expiry further extension can be obtained?
Yes, Lordship, that is
that liberty granted to you.
Lordship kindly sees the previous order.
If that liberty is granted, that after expiry you can seek extension from the trial court. Definitely, the trial court.
Well, it has not yet expired. It is yet to expire because this is now sent back to the trial court. There was an interim.
Very well. It is sent by back to the trial court. It is the trial court to decide. Now, your predicament is with regard to the interim order which was granted by the division bench.
Which was granted earlier and continued by division bench.
Yes, is going to expire. Okay. Now, whether the division bench has granted you the liberty that in the event of expiry.
That I would say is implied. If your Lordship feels otherwise, kindly make an order. We shall go to the division bench.
It's very difficult.
Lordship, I leave it to my Lordship. Can I record that? Then we shall go to the division bench and.
Because you see, had that.
Well, originally this
passed by the single bench. If it is single bench, definitely.
Originally single bench order that's passed on 13th of July 2022. Originally,
it is vacated with a limited extension
by the division bench.
Yes, so originally it is vacated. However, a limited
by a single bench.
Division bench.
No, it was vacated by a single judge.
Yes.
Kindly.
Yes, the interim order was enjoying stands vacated by reason of the return. This is the division bench order.
No, but the single bench order I returned the plate.
Yeah, by reason of the that was there. Shall continue. So this is the order passed by the division bench that it will continue for a period of 4 weeks. Okay. Thereafter, on 13th, no,
29th
thereafter
April.
on 29th April 2025, it was extended for a further period of 4 weeks.
In the disposed of.
So you obtained the extension from the division bench. Okay. So the first, this is 26 March. The second extension was obtained by you from the division bench.
Because the suit was not transferred as yet. Records had not, the suit had not been marked. So that's why we had to go before the division bench because the suit numbering, etc. had not happened and the department had not done the conversion.
In the absence of that liberty, this court.
Very well, Lordship kindly record that, then we shall go to
division. Record an order.
Well, in any event, my lord, my learned friends have, my lord, 4 weeks on 29th April. What is the urgency? Matter will have to be considered.
No, it's going to expire 27th of May. That's why, that's the urgency. It can be the urgency. That's within vacation.
Mr. Mitro, learned advocate for the plaintiff, and Mr. Shah, learned advocate for the defendant. You are Mr. Shah for all the defendants?
Yes, sir.
This is.
And Mr. Mitro is also for all the plaintiffs?
Yes.
Are present. Mr. Mitro submits that the interim order, which was passed in APOT 63 of 2025 on 26th March 2025 and subsequently extended on 29th April 2025 is going to extend on 27 is going to expire on 27th May 2025. Mr. Mitro submits that as because the suit is not yet transferred.
Was not transferred.
Not transferred. The interim order was passed by the Honorable Division Bench as an interim protection. But as the suit is already transferred, the plaintiff is praying for extension of the interim order that was originally passed by the Honorable Division Bench.
No, originally passed by the single bench.
No, it was vacated, you see.
Yes. Vacated and then continued.
That of the interim, limited interim protection was given by the Honorable Division Bench in APOT 63 of 2025. Stop. In the facts and circumstances, as no liberty was granted to the plaintiff to seek extension before the trial court for extension of the interim protection which was already granted. This court cannot extend the interim order passed by the Honorable Division Bench on 26 March 2025 in APOT 63 of 2025. Thus, this prayer for extension of such interim order is refused.
Lordship, may the order be uploaded today if possible, because then we should.
একটু তাড়াতাড়ি পাঠিয়ে দেবেন ওটা যাতে ইয়ে হয়।
Grateful to.
Fraction. Item number 64, Gautam Roy.
May it please your lordship. I'm appearing on behalf of the plaintiff. The witness is present. My lord.
This is item 36, 64. Right. The fixed matter.
My lord, before your lordship, my lord, before the witness begins, my lord, we are in the course of examination in chief.
Yes.
But I would like to point out, my lord, the last document which was, my lord, handed up, it has not been, the transcript doesn't show that it has been marked as Exhibit S. Because we applied for the certified copy of the questions asked last. My lord, that document
Anyway, that will be marked.
Exhibit. My lord, may I have a look at that document? Because I'm only apprehending that the document should be. It's a very old document. 147, 149. It is 8th May 1976. It should be Exhibit 8. Exhibit S. S. হয়েছে? একটু আর অবধি আছে। তারপরে একটা ছোট ছোট হ্যাঁ একটু দিন আমাকে একবার। Oh, yeah. My lord, it has been marked as Exhibit Ed. So, my lord, today, my lord, may I hand up the last day's deposition to your lordship once? It take two, my lord. That is what yes. I took din na, my lord. If your lordship, my lord, kindly sees the deposition, the last page of the deposition.
That is question number.
It should be, my lord, in connection with question number 147 to 152.
Yes, 147.
Yes, where, my lord, the witness talks about Exhibit S. It has been formally marked, but that has not gone down in the transcript.
Okay, that is,
my lord, it should be the letter dated 8th May 1976. It is the original document.
yes, question number 149.
149. If your lordship, my lord, directs, then that can, my lord, go in today. And thereafter, we can proceed with the next question.
Okay, should be passed after the examination.
My lord, now your lordship can dictate that
what has happened is the document has already been marked as an exhibit, as I understand. Only that the document
That has to be reflected in the deposition.
In the deposition.
That is basic.
Yes.
I am recording this thing.
Learned advocate for the plaintiff and learned advocate for the defendants are present. The learned advocate for the plaintiff. So this is the plaintiff's document. Plaintiff submits that the document marked as Exhibit S in connection with question number 149 and 150 of the said documents in connection with question number 149 and 150 is not reflected in the said deposition. Let the same be reflected in the said deposition with regard to question number 149 and question number 150.
And my lord, the document is tendered in evidence and marked as Exhibit S.
It's already exhibited.
Yes, but it should
And
be there in the deposition.
document be treated as Exhibit X. S.
Yes. For next. Together, regular shop together. My lord, may I proceed, my lord?
Yes.
I am showing you a bunch of documents which appears as PD12 and copies whereof are appearing at pages 59 to 61 of the judge's brief of documents. Kindly tell this honorable court, one by one, what are these documents?
After execution proceedings, that is on 8th May 1976, the judgment debtor A. Meyer and Company Private Limited filed a miscase number 30 of 76 arising out of title execution case number 8 of 70. And in that miscase, A. Meyer and Company, the judgment debtor, obtained a status quo order from the first subordinate judge. That order has been served on my father, trustee Shailendranath Rai, on 13th May 76. The service was made by special messenger under certificate of posting and registered with AD. This is the original envelope. Advocate was UN Banerjee, solicitor. Number 2 Church Lane. Address to Shailendranath Rai, trustee. To the estate of N. Roy Trust Estate.
So who has signed this document?
To the state of this document? To the state of N. Roy Trust Estate.
Who has signed this document?
This document was signed by UN Banerjee, solicitor.
How are you acquainted with the signature of Mr. UN Banerjee, solicitor?
During the course of searching of old records, I have found so many signatures of UN Banerjee, including the final degree passed in TS 42 of 80 before this Honorable High Court. There, in the minutes, I have found his signature. He appeared on behalf of Mr. Devendra Bajoria, defendant number 1.
May these be
Yes,
tendered.
the document be marked exhibit.
The transcript should go in, my lord. The original documents, copies whereof is appearing at pages 59 to 60.
No, this is the original documents. Yes.
The document, 3 documents are there, but 3 pages. 1 envelope and a letter, which comprises of 2 pages.
Let it be marked exhibit collectively.
Collectively.
Exhibit
T.
collectively.
For example.
T collectively. T.
I'm showing you a document a copy whereof is appearing as PD13 at pages 62 to 78 of the judge's brief of documents. Kindly tell this honorable court, what is this document?
My lord, this is a police report, combined police report of 144-2 filed by Mr. N.B. Roy on 13th May 1976 against my father, Shailendranath Roy Trust Estate, Shailendranath Roy Trustee, and the police officer also submitted along with another report, another application filed by Sri Umapado Banerjee on behalf of Sri Shailendranath Roy Trustee. Umapado Banerjee was the manager of Trust Estate. In this ancient document, it is clearly mentioned that on 8th May 1976, one Amol Dotto SP, 24 Parganas, that time it was not divided, to undivided 24 Parganas, was present on the site along with his men and agents, and Khaitan and Murthy, solicitor, was also present on the site, that is on 24th 4/2 Alipur Road, Calcutta. And Mr. Amol Datto challenged the court bailiff Adhir Krishna Mitra and said that delivery of possession to the degree holder is not possible. But subsequently, the solicitor Khaitan and Murthy along with Mr. N.B. Roy, they agreed to transfer possession of the property in favor of the trustee Shailendranath Roy, trustee to the N. Roy Trust Estate. This document further revealed that Mr. N.B. Roy filed a petition of complaint in the Court of Learned SDGM, Alipur, under section 384, 386, 147, 448, 323, 506.
147 তারপর
147, 448, 323, 506, and 104 by 34 Indian Penal Code against Sri Shailendranath Roy trustee and Shubir Rai and 30-40 other people. An order was passed by the learned court of SDJM under the above mentioned sections. As a result of which, my father and my brother, they had to obtain bail. It is also mentioned in the same police report that Mr. Bajoria was present on the site, and on humanitarian ground, the possession was delivered to the trustee, Shailendranath Rai. My lord, এখানে আমার একটা humble submission আছে, আমি একটু volunteer করতে চাইছি।
It go thereafter, it will be recorded. First of all, let the question which is asked, let it go.
Okay. And there were also some.
No, now you are volunteering.
It is chief, my lord, as it is voluntary.
No. He is to answer whatever questions is
Yes.
put to him.
As
Okay.
the lordship, my lord, feels.
Now, if he wants to volunteer something, then the court has to record. The witness thereafter volunteers. Now you want to volunteer something
Yes, my lord.
beyond the document.
Yes.
Yes, the witness now volunteers. Now what
That on humanitarian ground means that day in the afternoon, late afternoon, there was tremendous cyclone and storm, as a result of which Mr. N.B. Roy, the occupier, and the solicitor, they asked for some time to shift their goods or articles till 12th of May.
That's all. Yes,
my lord.
next question.
সেই কারণেই এটাকে হিউম্যানিটেরিয়ান গ্রাউন্ডে আমার বাবা অ্যালাউ করলেন।
That is why my father
allows
as a humanitarian
গ্রাউন্ড, হ্যাঁ,
ground.
4 দিন ওনারা থাকতে পারেন ওই লাইসেন্স।
They can stay there for 4 days. 4 more days.
That is by 13th of May.
13th of May.
They are to leave the premises. By 13th of May, they are to leave the premises without notice.
এই চিঠিটা আছে 12th মে চিঠিটা বা 13th মে চিঠিটা কি তার পরে যাচ্ছে?
তারপরে উঠে যাবে।
My lord, এর ভেতরে আরো অনেকগুলো জিডি এন্ট্রি সার্টিফাইড কপি আছে।
There are many GD entries inside the document. There are many GD entries inside the document
that due to the telephonic calls from Mr. N.B. Roy, police visited the premises on several occasions. I discovered this document much after filing of this suit from the record rooms of the trust estate.
Yes, next.
Can you please briefly indicate the dates of the GD entries you have mentioned in your earlier answer?
May 76, 10:30 hours, 11 hours, 13.45 hours. 13.45 hours, etc.
All the GD entries বলেছি বলতে।
All the GD entries.
এক এক করে সবকটা বলতে হবে।
সবকটাই বলতে
Oh. 13 point on the same date, 13.45 hours. 13.50 hours, 10.15 hours, etc.
10.15 hours and thereafter any other GD entry?
No, this is
So no question of etc.
Those. How did you obtain these documents?
I obtained this document from the office room of the trust estate at 4/1 Rai Bahadur Road, where Mr. Umapodo Banerjee, the trust estate manager, used to sit. This document was inside one iron almirah, and I noticed this document much after filing of this suit.
Not may this document be marked collectively as you.
Yes.
But I'm being led by Mr. Chatterjee.
Yes.
Actually documents.
Police report, দুটো police report combined.
Mr. Roy, I'm showing you a document which is disclosed as PD5 of the judge's brief of documents. Kindly see and tell my lord what is this document about.
My lord, this is the GD filed by my father, late father, Shailendranath Roy trustee, on 14th May 76, when our caretaker was forcibly ousted on 13th May in the morning. The GD that day, my father was not in town. He was in Chandanagar. And after coming back, he lodged this diary on 14th. And somehow 14th, it was not been recorded. Our trust estate manager waited whole day at Alipur police station, but nobody received it.
Nobody
Received it. On 15th of May, it was received.
Who is the author of this particular document?
Shailendranath Rai, trustee.
This complaint was registered in respect of which property? Can you tell, my lord?
This complaint was lodged relating to 24/2 Alipur Road, upper flat.
Are the contents of this document true and correct?
Yes, my lord.
Are you aware of the signature appearing in this document?
Yes.
Are you producing this document from your custody in the usual course of business?
Yes, I discovered this document also from the office of the trust estate subsequently.
বলে দিয়েছে। But may it be exhibited?
Yes.
So there are two documents. Collectively, it can be. Complaint at GD. Letter of complaint at GD. Exhibit কত mark হলো?
ভি হয়েছে, এটা ভি হলো, ভি।
পুলিশ কেসের এটা কত? পরের ডকুমেন্টটা? Mr. Rai, I am showing you a document. আচ্ছা, serial number C.
Serial number dot B.
What is B? Lolo. Mr. Roy, I am showing you a document which is disclosed by a letter dated 29th of April 2014 as serial number 3. Kindly tell my lord, what is this document about?
My lord, this is the degree holder's objection to the application under section 47 of Civil Procedure Code, which was filed by the judgment debtor. In that objection, written objection, my father trustee had elaborately discussed about that day's incident, narrated how Mr. HON'BLE SP, resisted the belief and decree holders, employee or manager of the trust estate, by strength of his power, though this property was completely outside the jurisdiction of Bengal police. This property was under Calcutta police that
Is it
time.
there in the documents or it is volunteered by you? The last two lines. This jurisdiction point is there in that. No, jurisdiction is there in the document. No, he is talking about jurisdiction of Bengal police. It is available from the document.
Can you brief? I'll put in a question with that so we can identify the person.
Yes.
Can you indicate, my lord, in which paragraph of this particular document the issue of jurisdiction which you have just indicated has been referred?
না মাই লর্ড, আমি এখানে এটা এক্ষুনি পয়েন্ট আউট করতে পারছি না,
No, I cannot point out this in the document.
কিন্তু এখানে অমল দত্তের উপস্থিতি
No, no, whatever you have stated, that jurisdiction point, Amol
জুরিডিকশন,
Datta's point.
হ্যাঁ ওটা আমি ভলেন্টিয়ার করছি।
No, no, first of all, is there in the document? Okay, let it be recorded. There is not, I cannot find out from the document.
Right this moment.
Are you producing this document from your custody in the usual course of business?
Yes, I obtained certified copy of this document after filing of this suit in the year 1990, 2000, in I obtained certified copy in the year 1999. 94 or 99, it is, I cannot make it.
94.
94.
No, this is a suit of 96. So how can you obtain certified copy in 94? This suit.
Suit.
Well, the suit originally was being filed before the Alipur.
Alipur.
So application under Order 7, Rule 10 was being filed before the Alipur.
Okay, okay.
It was withdrawn and it was filed before this
94.
order. 94.
Yes.
Because one of the main challenge to the suit is setting aside of a decree passed by this honorable court. So this honorable court will have the only jurisdiction to set aside its own decree. Who had signed this application?
This objection has been filed by my father, late Shoilendranath Rai, trustee, in presence of our trust advocate Nolinakho Chattopadhyay. Nolinakho, হ্যাঁ। এন চ্যাটার্জি এখানে লেখা আছে।
এন চ্যাটার্জি বলে তো।
হ্যাঁ, এন চ্যাটার্জি।
But may it be marked now. It's a certified copy.
Yes.
Collective. Exhibit oh হ্যাঁ W হবে W, হ্যাঁ collective.
Control document দিয়েছে বলে। Exhibit W, এটা হচ্ছে objection to section 47 application. Certified copy. Section 47 application of CPC. Objection. Mr. Rai, I am showing you a document which has been disclosed as serial number 5, wide letter dated 29th of April 2014. Can you tell, can you check this document and tell my lord what is this document about?
My lord, this letter was issued by one Devendra Bajoria, defendant number 1, on 22nd December 1976. The contents is, my dear Shubidda, I wish to advise you that I have received possession of premises number 24/2 Alipur Road, including both upper and lower flats. This is for your information. Yours faithfully, D. Bajoria. To Mr. Shubir Roy, Roy House, 4/1 Rai Bahadur AC Rai Road, Calcutta, 34. My,
Yes.
Who has signed this document?
Mr. Devendra Bajoria has signed this document. This is my lord, can I say? My lord, this is the fabricated document because
Okay, so
I'm
you have to volunteer.
volunteering.
What do you have to say with respect?
Okay, the witness now volunteers that this is a
This
fabricated
is a
document.
fabricated document because my father filed written objection on September 76. The cause of delay of filing written objection was he faced so many criminal cases and he was very much disturbed that time, and during pendency of that execution proceeding, how Devendra Bajoria can write this letter to Shubir Rai.
Write this letter.
Actually,
to
these explanations are given at the time of
Shubir.
cross-examination. Only I volunteered, it is a fabricated document.
Fabricated document,
So
my lord.
these explanations is not necessary usually.
At that-
At
at
cross-examination,
He
definitely.
has to clarify, he has
Yes.
to explain the document. In terms of this letter, did D. Bajoria receive possession of the property, subject property?
It was all along in his possession, my lord.
It was all in all.
It was all along in his possession.
How have you procured this document?
This particular document, along with some other fabricated documents, I found with the help of my aunt Sudharani Devi. Sudharani Devi, DEBI, Sudharani Devi, who used to reside with us. She was widow. She used to stay with us, and after my father's death, she used to look after all the affairs of the trust property as well as other property affairs. She helped me and told me when he heard that, when he came to learn that I have filed this one suit against my elder brother.
I have filed this suit against
She was very much disturbed.
Against my elder brother. She was very much disturbed.
She was very much disturbed, and I told her the entire story. Then she asked me to open my elder brother's room in his absence, because long absence, because my elder brother used to used to stay at Nagpur. So that room was under lock and key. My aunt told me that you must break open all the wooden, there was wooden cabinets. She told me to break open the wooden cabinets and make searching whether I can get some documents.
Whether I can get some document.
So it was recovered from my elder brother's room.
Yes.
May be exhibited. The letter.
X was right.
No, not X.
W হলো correct.
W হয়েছে একটা।
Y.
ও হ্যাঁ
Y হবে।
Y
হুম।
X হবে না X হবে না X প্যারেন্ট থেকে তো না Y হবে X টা বাদ হবে Y
হুম। এটা কোথায় ডিসক্লোজ হয়েছে?
PD4.
I'm showing you a document which is disclosed as PD. No, not PD4 now. এটা কোন disclosure? Sir, I am showing you a document which is disclosed in the judge's brief as serial number. In my lord, I'll just indicate the serial number. You can find it. Can you tell my lord what is this document about? Agreement. বলে দিচ্ছি না। 14(5) আমাদের witness statement দেখো ওখানে পেয়ে যাবে।
My lord,
বলে দিচ্ছি না, এক second।
this is a letter of tenancy agreement. Letter of tenancy agreement. Signed by my elder brother Shubir Rai and Devendra Bajoria on
And after he completes the question, I'll just indicate the disclosure number.
on
এটা হচ্ছে disclosure dated 2nd May
1977
serial number 2.
This tenancy has been given in respect of 24/2 Alipur Road, but one surprising thing is here Mr. Bajoria has mentioned his father's name as Chiranji Lal Bajoria. In 42 of 80 plaint, he has mentioned his father 80 suit 42 of 80 which was filed by Mr. Devendra Bajoria against Shubir Rai before this honorable court.
No, is it reflected in this document that what he mentioned in that plaint? That plaint is not, the question is with regard to this document.
His
Answer,
father is
yes, that much. That is name of the father mentioned
is Chiranji Lal Bajoria.
You may say that that is not correct.
That is not correct.
Yes, that much.
Does this document mention whether it was a trust property or not?
No, my lord.
Did Shubir Rai had the power
No.
to deal with Did Shubir Rai had the power to deal with this particular property?
No. he was not legally competent or nor he had any authority to sign this letter of tenancy. This is a fabricated document. Again, I repeat.
What is the date of execution of this particular document?
29th May 77. When there was so many criminal cases were pending against my father and my elder brother. And in some of the cases, FRT was granted by the police authority, Mr. Devendra Bajoria filed Naraji petition.
Petition. At the relevant point of time, where did Mr. Shubir Roy used to reside?
On 77, as far as I can remember, he was absconded because of his arrest. Because by that time, three of our employee was already been arrested by Amol Datto. That time emergency was from there from 76. They were under arrest.
Yes.
This letter of tenancy was in the back sheet of Rajesh Khoitan and Company, solicitors and advocate. Company, solicitors and advocates, number 2 Church Lane, Calcutta 1.
Who has signed on the respective pages of this particular document?
Shubir Rai and Devendra Bajoria.
Are you aware of the signature of Shubir Rai?
Yes, I am very much familiar with his signature.
I'm very much familiar. How have you obtained this document?
This document, along with that letter, all these documents have been discovered from the office of my elder brother, Shubir Rai, much after filing of my suit, as per instruction of my aunt, Sudharani Devi.
Mr. Rai, can you please come to the first page of this document and indicate to my lord the date which is mentioned as regards to the execution of this document?
This agreement is made this 29th day of April, whereas
No, 29th day of April, complete that. Thereafter you say.
29th of April, 1977. And at page 7, the date is given 29th May 77.
Yes.
In terms of this tenancy agreement, was Devendra Bajoria being inducted in the suit premises?
No, he was not been inducted through this document. It was, these documents were, these fabricated documents were created as larger conspiracy to grab one of our prime trust properties. Ultimately, Devendra Bajoria manufactured so many documents and procured my elder brother's signature somehow.
Oh, yes, what was your question?
একটু কোয়েশ্চেনটা রিপিট করে দাও। Was Devendra Bajoria been inducted?
Either yes or no,
No.
whether this document is genuine, that much.
This is a fabricated document, my lord.
But may it be exhibited?
Yes.
হাজারটা বলো। এটা কত হলো? জেড হলো না?
Exhibit Z.
এটা টেনেন্সি এগ্রিমেন্ট ডেটেড 29 এপ্রিল 1977। এটা কোথায় আছে?
Additional.
বলো সেটা।
May 2025.
এটা ইমেলটা না? Mr. Roy, I'm showing you a document which is disclosed by email dated 5th May. Can you tell my lord 2025 what is this document about?
My lord, this letter has been written by, it was written by one Mr. S.K. Shaha, number 4 Synagogue Street, Bada Bazar.
Yes,
I apologize
One.
for interrupting, my lord.
Let the witness first complete his answer.
Yes,
my lord.
yes, regarding
The new document, my lord. A new document that is being tendered for the first time, my lord. I do not stand in the way of it being tendered at the time of examination in chief. Only that, my lord, an opportunity may be given to me, my lord, for inspecting this document.
yes.
My lord, I do not join issue with that as well. It was given, my lord, for some miscommunication on our end, my lord. That was not done, my lord. Kindly an opportunity, kindly give us, my lord, to take inspection, my lord, and then, my lord, it can be tendered.
Yes, that liberty is there.
Very well.
এই চিঠিতে আমার বাবাকে কোনো একজন প্রিন্টিং প্রেসের মালিক জানাচ্ছেন।
In this letter, a person of a printing press informing my father, a person working in the printing press informing my father.
চিঠিটার ডেট হচ্ছে 28 মে 1977।
The letter dated
28th May 1977. It is written in vernacular.
It is written in the vernacular.
এই চিঠিতে উনি ডেসক্রিপশন দিয়ে বলছেন যে ওইরকম একজন চেহারার ভদ্রলোক এসে এখানে অ্যাটাচ করা রয়েছে একটা লেটার, বাবার লেটার হেডের উপরের অংশটা দিয়ে, যে কেউ বাবার লেটার হেড ওখানে প্রিন্ট করবার জন্য দিয়েছে।
In this letter, he has that person stated that one person came and asked for printing of a letterhead from that press.
হ্যাঁ, from the ওই প্রেসেতেই ছাপার জন্য দিয়েছে।
From that press.
সেই কথাটা যেভাবেই হোক তার সমস্ত ব্যবহারে বা ইয়েতে তার সন্দেহ হওয়ায় সে বাবাকে এই চিঠিটা দিয়ে বাবাকে জানায়। বাবা তার
When he has some doubt, then he informed my father.
And the witness had indicated that the letterhead of my father was being given for printing. Perhaps that has not gone in.
No, no.
এখানেই যে আমার বাবার
Your
লেটার হেডটাও
question was with regard to the who is the sender of that letter.
I had asked him to explain this document.
Explains means what is the contents of the
content
document.
of this document.
Yes.
He had indicated that
এই লেটার হেডটা
a
কপি করতে।
individual owning a press had written to his father that someone is trying to print your father's letterhead in my press.
Whatever is there,
That
that will
perhaps
go.
I don't know whether it
A
has gone in
letterhead
or
is
not.
attached.
আমি পড়ে দিন একটু answer টা।
Attached with this letter. এটা লাস্টে লিখে দাও। A letterhead is attached with the letter.
উত্তরটা পড়ে দেবে।
এটা বল। Printing press.
No, it has gone in as printing of a letterhead. The witness had answered printing of my father's letterhead.
Okay, let it go. Printing of the father's letter.
To which address was this letter sent to by Mr. Shaha, which you have just indicated?
Sri Shoilendranath Rai, 4/1 Rai Bahadur Road, Behala, Calcutta se
4/1 Rai
Rai
Bahadur
Road, Behala,
Behala,
Calcutta
34.
700034.
Can you indicate from the postal stamp and seal the period around which this letter was sent to your father?
এটা এই ডেটটা আমি পড়তে পারছি না, 31st হতে পারে, তিনটা পড়তে পারছি, May 77.
Okay, let it go.
The date is not
Whatever he has
legible.
stated.
The date is not legible. I can identify the month, that is May 1977.
Are you producing this document from your custody in the usual course?
হ্যাঁ, এই চিঠিটা আমি আমার বাবার অফিস রুম থেকে বাবার মৃত্যুর পরে আমার কেস ফাইল করারও পরে এই চিঠিটা আমি খুঁজে পাই।
I procured this document from the office of my father after the demise of my father and also after filing the suit.
হ্যাঁ, ফাইলিং অফ দিস স্যুট।
But may it be exhibited?
Yes.
Double A.
Double A. After after receipt of the letter, which has just been marked as Exhibit AA, did your father take any steps?
হ্যাঁ,
Yes.
আমার বাবা পুলিশে কমপ্লেন করেছিলেন।
Father lodged a complaint in the police station.
I'm showing you a document which is disclosed by email dated 5th May 2025. Can you tell my lord what is this document?
First June 1977 to the DCDD Calcutta Lalbazar, Calcutta 1.
The DC
DD.
D full stop C full stop D full stop D Calcutta Lal Bazar Calcutta 1.
And
বাবার লেটার হেডে এই চিঠিটা ওই সঙ্গেই আমি খুঁজে পেয়েছিলাম।
I have got this letter along with the
ওই চিঠিটার সঙ্গে,
along
ওই
with
মিস্টার
this
সাহার
along
চিঠিটার
with
সঙ্গে।
this letter, and this letter has been written on my father's letterhead.
letter of Mr. Shaha.
মিস্টার সাহার।
Letter of Mr. Saha, ওই যেটা বললাম। হ্যাঁ, this letter I have found this along with the letter Mr. Saha, and it is written on the on my father's letterhead.
Can you briefly explain the contents of this particular document?
Dear sir, one person is reported to have placed orders with a particular press at Bada Bazaar for getting printed letterhead letterhead pads in my name as per sample, which is actually my letterhead. The reported description of the gentleman leads to suspicion that he may be for Jibon Haldar. He
AIBA.
Jivan Haldar.
He is further reported to have requested the said press to observe secrecy in the matter in collusion with order. In collusion with other. I fear he is after getting hold.
I fear
He is after getting hold of letterheads for forgery and using it in my name for illegal and dishonest purposes.
Illegal and in my name
For illegal and dishonest purposes.
Are the contents of this document true and correct?
হ্যাঁ বাবা যা লিখেছিলেন তাই।
Yes, true and correct.
Are you producing this document from your custody in
হ্যাঁ
the
আমি
Indian
একই
court?
সঙ্গে ওই চিঠি থেকে নিয়ে একসঙ্গে আমি আমার বাবার অফিস থেকে পেয়েছিলাম।
I have got this letter along with the letter from my father's office.
And may it be exhibited.
Yes.
BB.
One last document, then I'll another document, then I'll close for the day, my lord. One more document.
Exhibit BB এটা হ্যাঁ।
The document of-
Letter.
এটা বিবি হলো তো? Mr. Rai, I'm showing you a document. Huh?
Number 7.
No, document. But I'm showing you a document which is disclosed, but I'll just indicate the disclosure. My lord. Kindly tell my lord একটু blank রাখুন আমি বলে দিচ্ছি। Watch, আমি বলে দিচ্ছি। Which is disclosed as lot 2, serial number 7. Disclosed by letter dated 29th April 2014. Kindly tell my lord, what is this document?
According to Lord B.
No, disclosure date বলে দিয়েছি। Disclosure date. এর আগেরটা হয় ম্যাডাম, letter of
My lord,
disclosure 2nd May 2014. 14, serial number 2. हाँ।
this letter is written, dated December 3, 1979, written by UN Banerjee in the letterhead of Rajesh Khaitan and Company. UN Banerjee, Ushanath Banerjee, the UN. This letter was sent by registered post with AD by special messenger. Shall I read it out, my lord? Or
What is the question? The question is the date of the letter and the sender of that letter.
At
Third
which
is-
address? At which address was this letter sent
It was
by the author of the letter?
Mr. UN Banerjee sent this letter to Mr. Shubir Rai at 4/1 Rai, Ombika Charan
4/1
Roy Ombika Charan Rai Bahadur Road, Behala, Rai Bahadur Road, Behala, Calcutta 700034.
In this particular document, who is being referred to as our client by UN Banerjee?
He has referred his client's name as Sri Devi Prasad, referred his client's name as Sri Devi Prasad Bajoria of number 3 Netaji Subhash Road, Calcutta 1.
Can you briefly explain the contents of this letter? ছোট করে বলে দিন কি আছে হচ্ছে।
My lord, এই চিঠিতে লেখা আছে যে মিস্টার দেবী প্রসাদ বাজুরিয়া 24/2 আলিপুর রোডের বাড়ির মর্টগেজের ওপর
It is written in the letter that Mr. Bajoria
একটা প্রমিসারি নোট ইস্যু 4 লাখ টাকা লোন দিয়েছেন আমার দাদা শ্রী সুবীর রায়কে,
Mr. Bajoria.
মিস্টার বাজুরিয়া,
Mr. Bajoria lent some money, lent of
rupees 4 lakh
4 lakh to my brother
Subir Rai
Roy
upon your executing promissory note and creating equitable mortgage of premises number 24/2 Alipur Road, Calcutta.
So this is the contents of the letter.
Can I submit, volunteer something, my lord?
This is the contents of the letter. Contents টা গেছে?
হ্যাঁ।
Now what do you want to volunteer?
My lord,
Yes, the witness volunteers.
volunteer করে লিখবে উইটনেস ভলান্টিয়ার করে লিখবে উইটনেস ভলান্টিয়ার
হাইকোর্টে যে সুট ফাইল হয়েছিল টাইটেল সুট নাম্বার 42 of 80
42 of 8 the suit which was filed in the High Court before the Honorable High Court being number 42 of 1980
সেটা ফাইল করেছিলেন দেবেন্দ্র বাজোরিয়া son of one নরেন্দ্রনাথ
that
বাজোরিয়া
suit was filed by Mr. Devendra Bajoria son of
নরেন্দ্রনাথ বাজোরিয়া
Narendranath Bajoria লিখেছো RIA Bajoria
এখানে আরেকটু উল্লেখযোগ্য জিনিস হলো যে এই 4 লাখ টাকা চেকে কোন ব্যাংকে দেওয়া হলো সেটা কিন্তু ওনার অ্যাটর্নি এখানে মেনশন করেননি যে কিভাবে দেওয়া হলো
his attorney has not mentioned that the 4 lakh rupees which he has been given the check, sorry, the check of 4 lakh rupees which he has been given to Mr. Subir Roy, he has not mentioned the check has been deposited in
Check
which bank.
check number and bank details.
He has not mentioned.
No, Subir Roy, he has not
Not
mentioned
mention the banker's name
the
or
banker's name
check
and
number
check number
in the said letter.
in this said letter.
Not only that, may I submit, my lord?
Yes, again you want to volunteer?
Yes, one line.
Yes, the witness further volunteers.
That এই 1979 এর আগে আমি ডিসক্লোজ করেছি,
as I have disclosed earlier that in the year 1979
যে আমার বাবা
that my father
24/2 আলিপুর রোড প্রপার্টির টাইটেল ডিড হোক বা নেসেসারি যা ডকুমেন্টস ছিল ফর ক্যান্সেলেশন ট্রাস্ট এস্টেটের অ্যাডভোকেট নলিনাক্ষ চট্টোপাধ্যায়ের কাছে কিছু সাসপেক্ট করে পাঠিয়ে দিয়েছেন।
that my father has some title deed that has been sent to by my father to my advocate
নলিনাক্ষ
Chatterjee to our advocate
for cancellation
for cancellation.
আর সেই ডিড গুলো আমি প্রায় 15 বছর বাদে যখন ওনার বাড়ি ভাঙা হয় উদ্ধার করেছি, আমি অ্যামেন্ডমেন্ট করে এই মামলায় সেই অরিজিনাল ডিড দাখিল করেছি।
And I have submitted all the original documents which I have recovered after 15 years.
সুতরাং এই চিঠিতে যে ইকুইটেবল মর্টগেজের কথা বলা হয়েছে,
so the equitable mortgage which has been mentioned in this letter,
সেটা হচ্ছে এটাও একটা ফেব্রিকেটেড ডকুমেন্ট।
It is also a fabricated document.
আগে সেন্টেন্সই কমপ্লিট হলো, আগে সেন্টেন্সও তো কমপ্লিট হয়নি, একটু
complete.
পড়ে দেবেন আনসারটা।
অ্যানসারটা একটু কি গেল একটু বলো, উনি কমপ্লিট করে বলেননি।
ফার্দার যেটা
হ্যাঁ ফার্দার ভলান্টিয়ার
I have disclosed earlier that in the year 1979 that my father
had already sent the relevant deeds to the advocate of the
trust to the advocate of the trust, Mr.
Nolinakshu Chatterjee for cancellation apprehending some mischief. Long after when Mr. Chatterjee's house was immediately before demolition of his house for rebuilding purpose, his son requested me to collect all our papers from his father's office. I found the original 1971 deeds from the residence of our trust advocate, Mr. Nolinakho Chatterjee, much later, after filing of this suit, and I have on earlier occasion submitted those deeds and letter written by my father before this honorable court.
Can you indicate in respect of which property the equitable mortgage was purported to have been created?
It has been purported to have been created in respect of 24/2 Alipur Road.
You have asked this question earlier?
No, in respect of other document.
Okay.
Does this document also finds any mention whether 24/2 Alipur Road was a trust property or not? Or not?
On that deed, it was mentioned that 24/2 Alipur Road was trust property.
Are you producing this document from your custody in the usual course?
Which one? This letter. This letter I have recovered. This letter I have recovered from my elder brother's office in presence of my aunt.
May it be exhibited?
Yes.
Only one page last
DP
document,
হয়েছিল
if
না?
I may exhibit my lord. এটা হচ্ছে exhibit
Exhibit CC. সিসি হলো হ্যাঁ সিসি
Mr. Roy, I'm showing you a document which is disclosed by email dated 5th of May 2025. Can you tell my lord what is this document?
That is 5th of May 2019?
5th of May 2025.
2020.
A disclosure email.
My lord, the date of the letter is written by me 30th December 1992. That time, massive renovation was going on in our residential house at Behala, and I used to stay at 5 Lindsay Street. Lindsay Street. I filed title suit number against Devendra Bajoria and Binaguri Investment Company on 30th November 1992. It is immediately after that আমাকে কেউ ফলো করতে শুরু করে।
Someone was started following me
বিভিন্ন জায়গায়
at various places.
আমি তার গাড়ির নাম্বার দিয়ে তালতলা পুলিশ স্টেশন, বেহালা এবং আলিপুরেও কমপ্লেন লজ করি।
I've lodged some police complaint in the police station, Behala,
Taltola,
Taltola, and
and Behala and Alipur police
at
station.
Alipur police station along with the vehicle's number, vehicle's registration number.
এই আমি গাড়ির নাম্বার এবং যে নামটা পেয়েছিলাম তার নামে কমপ্লেন করেছিলাম।
I have lodged the complaint against the person against the person
with his car number.
with his car number.
প্রত্যেকটা ক্ষেত্রেই আমাদের যেখানে যেখানে আমি গেছি সেখানে দারওয়ান বা সিকিউরিটি গার্ড বা যারা যারা ছিল সেখানে একটাই কথা বলা হয়েছিল that my life is in danger.
I have stated wherever I go in front of my
my life দারওয়ান বা যে
in
সেখানে
front of
ছিল
the janitor,
সিকিউরিটি
guard, security guard, in front of security that my life is in danger.
এই মেসেজটা দেওয়া হয়েছিল সব জায়গায়।
This message has been given everywhere.
আমি সেটা জিডি করেছিলাম।
I filed a GD in respect of this.
Does this document contain seal of the relevant authority before whom you had lodged the complaint?
যেখানে আপনি এটা লজ করেছিলেন সেখানে কি কোনো সিল বা
হ্যাঁ হ্যাঁ হ্যাঁ
yes,
Who has signed this document?
আমি সই করেছিলাম।
I have signed on this document.
Are the contents of this document true and correct?
হ্যাঁ
Yes, true and correct.
Are you producing this document from your custody in the usual course of business?
Yes. Answer?
And
Yes.
may it be exhibited.
So examination in chief complete.
No, Mala, there are few more documents.
Few more documents.
Out other side of the vacation will come back.
আগেরটা কত হলো গো?
My lord, may I
But
ask
BT
only
hall.
one indulgence? I did not wish to interrupt, my lord, my learned senior friend in the course of examination, my lord. The new documents, my lord, that are being produced today, my lord, under
Only
cover of-
one document, I believe.
No, my lord, several documents under
Several
cover of the
documents?
email of 5th of May, my lord. Roughly, my lord, 3 documents have been produced.
2025.
5th of May, my lord. May that only be go in as under objection, my lord.
But we had written.
Better you take, I am granting you liberty to take.
Yes, let them take.
Yes,
it,
record
all
and order.
original doc.
Very good.
Sorry.
Learned advocate for the plaintiff and learned advocate for the defendant are present. PW1, this PW1
PW1.
is present in court. PW1 is examined in chief in part and discharged for the day. Documents filed be marked exhibits. Further examination in chief is deferred on the prayer of learned advocate for the plaintiff. Mr. Sen, learned advocate for the defendant, submits
My lord,
that
defendant number 3, man. Defendant number 3.
defendant number 3 submits that some documents have been produced to the witness without that being disclosed. Stop.
Well, we had disclosed it. It was disclosed by a covering email, my lord. We had offered them inspection also. They refused inspection.
Which is disputed by the learned advocate for the plaintiff. However, in the interest of justice, let opportunity be given to the defendant number 3 to inspect the said documents. In the meantime, let this matter appear on, yes, after vacation, but complete on the said day.
I will try and do that. I mean, majority of the documents have gone in, perhaps.
Yes.
More available.
18
very good.
6 2025.
Huh? Oh, 19.
আচ্ছা,
My lord, 19th, could it be 19?
এই 1 মিনিট 19 তারিখে 2টোর সময় বা 3টের সময় কিছু আছে দেখে
19 অসুবিধা আছে তোমাদের? 19 অসুবিধা আছে তোমাদের?
Sakshi's availability.
19 তারিখে 3 PM আছে আর
25-এর পরে availability.
3 PM for hearing আছে 3 PM নেই 18 তারিখ 3 PM 18th you have some difficulty
But well, there is some inconvenience on the part of the witness, my lord.
on 18th.
He was requesting if it can be done after 25th sometime. After 20th, man. 23rd, if your lordships
No, no, after 20.
20.
0. আচ্ছা 24 তারিখে কিছু নেই না? 24 তারিখে আছে।
23rd
23 তারিখে নেই।
at 2
আচ্ছা 23
at 2 p.m.
23 6 2025 at 3 p.m. At 3 p.m.
But I was only suggesting, my lord, if it being fixed at 2 p.m., I'll try and conclude on that particular
No,
time.
3 p.m. you will not get time. You have almost
It's a-
90% you have completed.
It's a 3:30.
But after all, Mr. Sen may take some time because you will also not be able to complete. Definitely it has to be adjourned. Better you complete your part.
Very well. Well, we apprehend if there's a 3:30 resolution, then we get
Half an hour is sufficient.
very well. I'll try and conclude that. But
Tell the witness should give specific answers,
that
not
will certainly
the history.
indicate, my lord.
And these should be there in your plate. Otherwise, entire thing will be inadmissible.
Oblige, my lord.
Anyway, 23rd at 3 p.m.
Very good.
Deeply blessed. The 3 p.m. matter to take it in.
For argument cited number 62, Mr. Shomir Bhattacharya.
I am for the defendant in this matter. The matter has been
Start.
I am to start, my lord. My lord,
I'm for the plaintiff.
my witness was in the box on the last occasion. So
So you have
therefore,
to start.
may I start, my lord? Yes. My lord, this is a very interesting case of a matter of malicious prosecution. We generally do not get these cases in our regular usual course, my lord. But may I first indicate the basic facts of the case on the basis of which the particular malicious prosecution has been alleged. My lord, this matter arises on the basis of an order passed by the Delhi Rohini Court in relation to a 138 proceedings. My lord, there was a transaction being carried out between the defendant and the plaintiffs in the nature of certain aromatherapy or cosmetic business, and the plaintiff was an agent of the defendant in Calcutta. The defendant was then a sole proprietorship concern. Subsequently, my lord, they have now other subsidiary organizations and also converted into a company much later on. But my lord, that company is not a party. In any event, my lord, it was a sole proprietorship concern at that stage. And Mr. Sehgal, SC Sehgal, was the sole proprietor, who is the defendant number 1. Now, my lord, after the particular transaction which was going on for the initial time being in central Kolkata, he was one of the agents and he was carrying on the particular transaction as an agent on behalf of the defendant or a supplier. My lord, certain disputes and differences arose with regard to the products and the nature of the products. Initially, an attempt was made to settle the disputes.
That 138 case.
Well, thereafter we come to the 138.
Yes.
So initially there was an attempt made to settle the disputes. The parties sat across the table. There was inventory which was to be returned to us and payments which we would have made in return, and also certain inventory for which he has conducted sale. He was supposed to give us the balance amount. Now, my lord, there were two checks which were given to us, to the defendants. The defendant, being an entity as sole proprietor in Delhi, had presented those 2 checks. These 2 checks were drawn on Maniktala branch by the plaintiff, handed over to the defendant. The defendant goes and encashes or presents the check before its banker in Connaught Place, New Delhi. The 2 checks were dishonored. After the 2 checks were dishonored, the defendant took legal advice and filed a matter before the Rohini Court in terms of section 138, 141 and the relevant provisions of the Negotiable Instruments Act. And my lord, once the particular matter was filed before the Rohini Court, this matter initially this was filed in 2014. Thereafter in 2016, the defendant had obtained a bail and the matter proceeded.
The accused.
The plaintiff here, my lord. The plaintiff went to Delhi, obtained bail, and thereafter the matter proceeded. Now, my lord, firstly, so this matter went on for about 8-9 years, and thereafter, when the matter had come to a conclusion, a judgment was passed. On the basis of that judgment, now the plaintiff has filed a suit in Calcutta on account of the fact that the cost that he has incurred for the entire proceedings was in view of a malicious prosecution, and therefore the plaintiff is liable or is entitled to recover the entire amount. Now, my lord, may I indicate that what are the main vital factors? My lord, the entire basis of the plaint is an order passed by the Rohini court in Delhi. What is the nature of the proceedings that was filed, whether the proceedings was filed before a court having jurisdiction or not having jurisdiction. Because, my lord, today, if I have a case, I can file a matter. If I cannot prove it, it will go against me. If I prove my case, then I get necessary orders. But would that amount to being a malicious prosecution against another person? Therefore, in that circumstance, a lot of people will not be able to even fight for their right or their legal entitlements. So, my lord, this particular criminal case.
Malicious prosecution is applicable only if you file criminal case, not civil case.
My lord.
Only a criminal case.
My lord.
So people will think twice before proceeding under the invoking the criminal law.
My lord.
You see, everybody has a right to justice. Okay.
Indeed, my lord.
But question is, this malicious prosecution is there because so that this criminal law is not arbitrarily invoked.
Indeed,
indiscriminately.
Indeed,
so this malicious prosecution is a check that before proceeding against a person in the criminal court, people will think.
Indeed. So, my lord, this was 138 proceedings, which is in the nature, somewhere in the nature of a criminal proceeding, but with regard
to. But it can be compounded also.
Indeed, my lord, it can be compounded. It was for the purpose of recovering that particular amount from the plaintiff.
It was disposed on merits.
My lord, it was disposed on merits, saying that I could not prove my case beyond any reasonable doubt, because, my lord, the tests are different. In a criminal proceedings, I have to prove his mens rea in not making the payment. From my documents, I could not successfully prove beyond reasonable doubt that his case, rather he had mens rea in not giving me that amount.
Anyway, so any other proceedings filed, civil or
no, my lord, no, my lord. Only one on the basis of those two checks. My lord, what is even more important is he comes and says, I have been aggrieved for the last 10 years. And this matter has been dragged on for 10 years and I'm entitled to payment.
10 years the matter went on?
Yes, my lord. 8 years almost it went on. 10 years. No? It went on for 10 years, my lord. Now the issue is, for the first 2 years, he was not even aware. 4 to 2006, he was not even aware. Then he later on visits Delhi, not a demurrer application filed. If I am doing a malicious prosecution in a court which does not have jurisdiction, and knowing that I am proceeding in a matter, the first objection that the other side would take is come and file a demurrer application.
Yes.
No demurrer application filed. My matter is proceeding. I have produced lot of documents in support of my case. I have tried to argue my case, and in that manner I have proceeded. However, during the entire process, the plaintiff does not come forward and file any demurrer application. Whether now the court did not have jurisdiction, he has not raised it. The court does not go into this issue whether the court had jurisdiction or not.
Had jurisdiction, it decided the matter on merit.
Indeed, my lord.
So there was no application against that order because.
Indeed, my lord.
No. Against that acquittal, did you challenge?
No, my lord. I did not challenge because the issue is, this question has been put to my witness, and my witness has answered that the quantum was so little, and we had fought a case for 10 years. And
quantum was how much?
quantum was approximately 30 odd lakhs.
30 lakhs.
Yes, my lord. Or even less, my lord. Huh? Even less, my lord. I may be certified property secretary. Yes, my lord. 12 lakhs. No, 1 lakh. Approximately 2.5 lakhs.
12.5 lakhs.
2.5 lakhs.
2.5 lakhs.
Yes, ma'am. My lord, the first check is with regard to 50,000, and the second check $38,543. So it's 88,000, my lord, not even lakhs. So this was the quantum for which at matter
15.
2000 the order has been passed. This is a complaint of 2003, order passed in 2013. So 10 years, 88,000 a matter went on. I did not get my money back. My main intention was to recover my money. Now, we all know that in commercial transaction, this was a commercial transaction, and my intention was to settle the disputes, recover my products, and give him or get whatever balance dues from him. He had given the checks because that was in lieu of the goods that he had sold, my goods that he had sold. But there was supposed to be an inventory, there was supposed to be a balance, which we did not come to a conclusion, which is why the disputes continued. However, we stopped transactions altogether. My entire object of filing the 138 was the fact that there will be some form of a resolution, or he will come across and make that payment.
During pendency, was there any attempt to
No, my lord.
resolve or settle
No,
the
my lord.
dispute? No attempt.
Because, my lord, understands 88,000, if it had come to me, I would have taken the amount and I would have finished off the chapter. Today, the cost incurred for this proceedings, the cost incurred in the Rohini court proceedings over 10 years, that is today a much larger amount. So the intention was never to pursue, and this question was put to the witness. I shall indicate the answers of the witness as well. The witness answers that I did not pursue an appeal because it had become redundant. The amount was so little that it had become redundant. So, and I signed it was from 2003 to 2012. 7th September 2012 is the order.
How much is the damages claimed?
My lord, the damages that has been claimed is 1 crore 40,000. 40 lakhs 98,000. My lord, will come to page 19 of the plaint.
Yes.
1 crore 40 lakhs.
1 crore 40 lakh
98,810.
Special damages 1 crore 10 lakh.
My lord, what is interesting is not special damages and general damages. No. Special general damages of 30 lakhs out of the 1 crore 40. The particulars start at page 16, my lord. And I will come to the quantum, my lord, later on. What is most important is, for the purpose of identifying a case of malicious prosecution, there should be some malice, iota of malice against me. I should have filed the matter in a court not having jurisdiction. They have harped on the fact that now may I kindly place the plaintiff before my lord. What is the plaintiff's case? The plaintiff has deliberately gone on the premise and said that this was a transaction happening in Vivekananda Road, Kolkata. This is a transaction where Maniktala branch I have given the check, and on the basis of this check and this court, you ought to have come here and filed the proceedings. But my lord knows that with regard to the jurisdiction
Where
under
is your office situated?
my office is in Delhi.
Your office is in Delhi.
My lord will kindly take the cost type.
And the check was dishonored in Maniktala branch.
No, my lord, it was presented in Knott Place branch, Citibank.
That is in Delhi.
In Delhi. and it was presented there, and it had been dishonored there. I had gotten the return memo from the Connaught Place branch.
No, placed in the Delhi bank, Delhi branch.
In the Delhi branch.
Both the checks.
My lord, he has drawn the check in Maniktala.
No, that may be. But where is
Both of
your
them.
office situated?
Delhi.
And where did you present the check?
It isn't situated in Delhi. I presented it in Delhi. So, my lord, may I quickly take my lord through the basic pleadings in the plaint, my lord, just to give an overview of the case and what the fact that what the case has been filed in respect of. My lord will kindly take the plaint. My lord will see that the plaintiff, firstly, my lord, these are very frivolous points, but nevertheless, there is a misjoinder of parties because there are two persons who are the same individual entity in the eye of law if my lord takes up the cause title. May I start from the cause title itself?
Yes.
Shomir Bhattacharya carrying on business under the name and style of Messrs. S. Bhattacharya as proprietor. So, my lord, this is the individual. Second is Messrs. S. Bhattacharya, a proprietorship firm carrying on business from so and so. It's the same address, my lord. So, a sole proprietorship firm is not a legal entity, could not have been made a party. Very well. Oh, my lord, I'm corrected that it has been amended.
Yes,
It has been amended.
No more there. I find it the amendment here.
My lord. Irrespective, my lord, then I come to the next page. Then, my lord, I stand correct. In my copy, the amendment is not there. In any event, my lord now will kindly take up the pleadings in the plaint, my lord. So he indicates that the plaintiff is the proprietor and has been carrying on business from a particular place. Then, my lord comes to paragraph 2 at page 4.
Yes.
My lord, I will take some time. If my lord so pleases, I can come back after the vacation. Otherwise, I can proceed. I am after the vacation.
Okay.
Continuous intrusion from my learned friend. What? That keep it after
Yes,
the
keep
vacation.
that-
No, I agree. I agree with my learned friend. We'll come back after the vacation, my lord.
Learned advocates for the parties are present. Learned advocate for the plaintiffs
Will you agree that Mr. Banerjee is a bully?
Never. Commences his arguments but could not conclude the same. Let this matter appear on (24) 6 2025 at 2 p.m. Okay, let it be at 3 p.m.
Anything. My lord, what I will do is I will come back with a note. There is only one other aspect is the.
It will not take much time.
No, my lord. I will come back with a note with my points and the judgment and the paragraph numbers. Only other thing I will point out is with regard to the quantum, because I believe my lord has understood my argument with regard to the jurisdiction issue and malice. Those I will only.
That would be better. You come with your written
note,
notes of
my lord.
arguments
I will
and
do that.
so
I shall
that
do
it
that,
can
my
be
lord.
concluded.
I shall do that.
Your Lordship, the written notes may be exchanged, Your Lordship, so that also we can.
Yes, written notes has to be exchanged.
না না ও প্রায় একটা দিয়ে দিই ঠিক আছে দিয়ে দেবো
My lord.
গ্রেট
Yes. ডেকে আর আছে নাকি? জিজ্ঞাসা করে নিন এনি ম্যাটার্স বোথ সাইডস প্রেজেন্ট, তাহলে সেটা ডাকা হবে।
Right, 39. My lord, item number 13, if my lord kindly takes up.
Item
39, your lordship. This has come up at my instance. I am the
Yes.
plaintiff in this matter.
Yes.
My lord, the matter is at witness action stage, your lordship.
Yes.
Plaintiff number 2, if my lord takes the orders once, your lordship, the last order of 24th January 2019. My lord, this was the order passed by Honorable Justice Mushmi Bhattacharya, as his lordship then was. My lord,
To examine
directing
will
that the
continue.
yes, my lord.
That is PW2.
Yes, my lord. PW2 is my lord Tara Shankar Ganguly. His witness action is still my lord.
That is PW2.
PW2, my lord. Thereafter, he has given a power of attorney to his wife and Parvati Ganguly, my lord, and Parvati Ganguly will my lord depose before your lordship. I'll make a my lord formal application regarding this, your lordship, as well. And now, my lord, if my lord kindly takes up this order as well, your lordship, on 7th January, my lord, we have
It's
indicated.
difficult. Otherwise, I can do one thing.
My lord.
Instead of doing all these things, power of attorney, it's better I let the commissioner be appointed if he is unable to come.
Commissioner.
He's still alive.
Yes, my lord, he's there.
So let a commissioner be appointed who will go there and examine him and better.
My lord, that
Instead
can be done, your
these
lordship.
are these will all create complications.
Yes.
This power of attorney is
Very well, your lordship, as it has fallen from my lord. I'll just indicate, my lord, what is the update of the my lord this
39.
suit. My lord, item number.
You are for the plaintiff.
I am for the plaintiff, my lord. My lord, this is the my lord, my lord.
Where this person decides, this PW.
My lord,
Oh, then there's no problem. Yes, record an order.
Salt Lake, your lordship. Salt Lake.
Learned advocate for the plaintiff is present. This matter is pending for witness action. As PW2 was examined in part, let this matter appear for witness action on. When shall I keep it? On that day you make necessary application.
I'll, my lord.
Or else you.
My lord,
or
if
else I
kindly
shall
keeps
hear
it for witness action, my lord, I'll take instructions from my
If you only order prayer, it can be considered.
my lord. So great.
Let this matter appear under the heading witness action on 17/6/2025.
My lord.
At 4 p.m.
4 p.m. এখানে হবে আমরা তখন যদি দরকার আমরা অ্যাপ্লিকেশন করে বলে দেবো কিংবা ওরাল অ্যাপ্লিকেশন করে দেবো my lord we have already served the my lord the notices
Yes,
to the defendant as well, your
Learned
lordship.
advocate for the defendants be intimated by notice.
My lord, I'll
Yes.
Item number 60,
Ah.
framing of issue.
এটা 4টের সময় রেখেছি।
আমরা এখানে জানিয়ে দেবো সেটা।
My lord, item number 63, framing of issues. Mention.
Yes.
My lord, matter is appearing in the list, but
You are for?
I am for the respondent.
Defendant.
Defendant.
Yes.
The last date, my suggested issue that the admission affidavit of admission will not be traced out. But I have come with that. My lord,
My lord, these are the suggested issues of the defendant.
You mentioned plaintiffs have already filed the suggested issues.
Plaintiffs had also filed. In fact, as defendant, we filed it earlier. It was not being able to. We were not being able to trace it out. And your lordship will kindly see the affidavit of admission and denial of the documents.
So let this matter be taken up for consideration of the issues.
Yes, your lordship.
After
That
vacation.
it is appearing today in the list
So
under the heading for framing of
So as
issues.
because the suggested issues have already been filed by the parties,
Yes.
let this matter appear after vacation for consideration of the issues.
Very well.
Yes, item 63.
And my lord will also record that we have handed it over afresh. The admission
Advocates
denial.
for the parties
Defendant.
are present.
Yes.
Learned advocates have filed today the suggested issues. Let the same be kept with the record.
Suggested issues of the defendant we have filed.
Suggested issues of the defendant
Is filed along with the
Filed.
affidavit of admission and denial of the
along with the
documents.
affidavit of admission and denial of the documents. Let this matter appear for consideration of the issues on anyway after vacation, that is 19/6.
Yes, your lordship.
19/6/2025.
Grateful.
ঠিক আছে আর আছে yes Mr. Ali.
Lordship 40, item number 40 is my matter. I am for the plaintiff, my lord.
Yes.
This matter, lordship, the written statement has been filed.
But in this matter, I appear for the defendant number 1 against the still works.
What is the stage?
The stage is only the written statement has been filed. We have given them a notice for inspection. Lordship, no
So let it
inspection
be
has been
completed,
taken.
let it be completed so that it can be taken up at the end of June.
Lordship, that's what I'm saying. Lordship, for framing of issues, mother.
And only one thing in this matter, only yesterday I have got the instruction to appear.
Anyway, you take the necessary documents. I'm keeping it at the end of June.
Lordship keeps it in the end of June for framing of issues, mother, on the heading. Lordship,
Discovery and inspection in the meantime. Yes, learned Mr. Ali, learned advocate for the plaintiff. Yes, your name, please. Mr. Subroto, Mr.
For one and
Somnath Gangopadhyay.
One. Defendant number one.
Representing the defendant number one are present. As the written statements by the defendant number one is already filed, let the matter appear for framing of issues on 25/6/2025. Discovery and inspection shall be completed in the meantime. The other defendants entered appearance.
they have entered appearance, but sale has the
Anyway,
number two. They have not used any.
This learned advocate for the plaintiff is requested to intimate the next date of hearing, next date, to the learned advocate for the defendant number 2 and 3. Defendant number 2 and its learned advocate.
Learned advocate of defendant number 2.
Yes, learned advocate of the defendant number 2.
এর কি হয়েছে অ্যাপিয়ার করেছিল এর আগে
বলছি তো
ঠিক আছে
I'm great.
25th of June.
25th of June.
Lordship, may I be permitted to mention item number 54 and 55?
Yes.
Lordship, I am for the plaintiff. I am praying that the matter may be kept after vacation. We need to come back with necessary.
Item 54 and 55. But what is the stage of the suit?
Lordship, in this matter, the amendment was allowed and amendment has been made.
No written statements filed.
No, Lordship. We'll
Why
just
are you
come
not?
back with
But the matter
instruction.
is appearing in the list for long period. Why are you not appearing?
Lordship, I am for the plaintiff.
No. But why are you not appearing? It is appearing in the list for a long time.
Lordship, we are.
Anyway, item 54 and 55. লিখে নিন on the দুটোতে একই order হবে. On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 23/6/2025. Learned advocates for the plaintiff shall intimate the learned advocate for the defendants by notice about the
Lordship,
next.
they have not yet appeared.
Service is complete.
So we have to come back with necessary instruction whether it is
Okay,
complete. or
learned advocate for the plaintiff shall obtain necessary instructions in this regard. Yes, 23/6.
Grateful, Your Lordship.
ঠিক আছে ডেকে আচ্ছা কালকে একটা ম্যাটার চেম্বার ম্যাটার একটা শুধু থাকছে একটা ম্যাটার চেম্বার হয়ে গেলেই শুধু একটা ম্যাটার থাকছে চেম্বারে কালকে জাস্ট ওই যেরকম হয় ওই খুব পড়ে নেওয়াই ভালো প্রসেস রাখা যদিও আমি রাখি না একটা এক্সেপশনাল সার্কামস্ট্যান্স বললো তাই জন্য রাখলাম দরকার নেই 10 মিনিটের ব্যাপার মিটিয়ে ফেলবো আর আরেকটা জিনিস ওই মেনশনিং এর সময় বলে দেবেন যে অনলি চেম্বার ম্যাটার আদারওয়াইজ কনফিউজ হয়ে যাবে কোন ম্যাটার মেনশন করছে কোন ডেটে কোনটা ঢুকে যাচ্ছে কোনো ঠিক নেই একদম স্পেসিফিক্যালি